Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will be your guide on this 3-hour journey through Courtlandia. We're starting in Royal Oak, Michigan. This is Magistrate Urich.
Oak Police Department, you are in the right place. Please listen carefully. The court is going to explain the procedure for these hearings to you as a group, and then we will undertake your cases one at a time. So to begin with, these are civil cases of a non-criminal nature. Nobody's going to jail today on their traffic ticket. It is, however, considered serious enough that the officer issued you the citation on the date in question. You will be required to make a selection from one of three options, and three options only in the protection of your rights. You may, if you wish, simply admit responsibility to the citation. The court will attach a fine between 0 and the maximum, and that'll close the case. Your second option is to admit responsibility, but with an explanation that you believe mitigates your circumstances. And your third option is to deny responsibility. If you do so, the court will swear the parties under oath and conduct your trial forthwith. The officer testifies first. It's their burden of proof. Then it is your turn to testify. Tell the court what you wish the court to know, and then the court makes the finding of responsible or not responsible. Please remember, since we're in civil court, that burden of proof is a mere preponderance of the evidence. It is not the heavy burden of proof of guilt beyond a reasonable doubt, which is reserved for criminal court. Lastly, this court, this umpire, the magistrate here, does not have the legal authority to add or subtract points. That is between yourself and the Secretary of State. However, anything you do say can be taken into consideration by the officer, but the court's not here to haggle with you. The court's here to accept a plea, and then we move on from there. So with that said, I'm going to excuse you back to the waiting room. Please have any documents you need or your testimony ready, should you choose to go that route, and the court will be with you shortly.
Well, Magistrate Urich immediately gives us some dead air time. Once again, let me say good morning to everybody. TCF Live on this wonderful Wednesday, which for this week is kind of the new Thursday because tomorrow will be the new Friday. Slow start in Courtlandia, which is why we're starting here with the magistrate. So we'll give him a second to see if he wants to actually participate. Otherwise, I will find us something else, though, again, not many choices yet. But
More than fair.
there we go.
Calling
Okay,
case number
thanks.
26, RO 01258, People versus Melissa Dana Lewis. That's you?
Yes, Your Honor.
Good morning again. Ms. Lewis, you were present just a moment ago when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court to instruct that you must select from one of three options to protect your rights. Yes?
I do.
Thank you, Ms. Lewis. The citation before the court was issued March 5. This year at about 8:06 in the evening, you were operating a 2019 Mercedes black in color on Washington Avenue at or near Lincoln. And at that time, you were cited for disobeying a traffic control device. Officer Cole's remark on your ticket indicates driving northbound Washington approaching Lincoln, failed to yield to solid yellow and proceeded through red light. And apparently there's a dash cam capture of this. The motor vehicle code indicates that motorists must stop on a yellow light if that is a safe stop under all circumstances. But notwithstanding that, Ms. Lewis, you do have your three options today. You may admit responsibility, you may admit and explain, or you can deny responsibility. The court will swear the parties and take your testimony. What do you want the court to do for you?
Your Honor, I'd like to admit and with an explanation.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak. And at that place in time, you disobeyed a traffic control device, correct?
Correct, Your Honor.
Thank you. Miss Lewis, what do you want the court to know?
That night it had rained all day that day and it was like torrential pouring. I was going 5 miles under the speed limit as well because I've gotten in my first accident when I was a child. It was raining, so I drive really slow during the rain. And the light was turning yellow and I was like coming up to the spot, I guess. And I did start braking, which you can, and I did see the cop in front of me and I started braking and you could probably see that on the video as well. But I felt like I was gonna slide through traffic if I did that. So I originally started to brake, kept going, went through before they even turned their lights on and pulled around to pull me over. I pulled over because I knew I was gonna get in trouble, but I just didn't want to like slam through the intersection while it was raining, just in case. I thought it would be the safest for me to go through it. And if I were going the speed limit, if I was going faster, I think I would have gone through the light. I just didn't think it was safe for me while it was raining. And the video should show that as well.
Your judgment call. Thank you. Ms. Lewis, the court appreciates all your remarks. And turning to Officer Cole.
A motion to amend to impeding, Your Honor.
Okay, impeding traffic. Thank you, officer. Ms. Lewis is a 0-point violation, will not permanently appear on a master driving record. That's acceptable to you?
Yes, Your Honor. Thank you.
Very well. So your original plea will subsume a plea to impeding traffic. The fine, Ms. Lewis, is $75 that is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. That completes your hearing. Good luck to you.
Thank you. Have a good day.
Take care.
Bye-bye.
Calling case number 26RO01717. This is People versus Jack Thomas Bruner. That's you, sir.
Yes, sir.
Mr. Bruner, you were present earlier today when the court explained the nature of an informal hearing. True?
Yes, Your Honor.
So you understood the court to instruct that you must select from one of three options to protect your rights. Yes?
Yes, Your Honor.
Thank you, Mr. Bruner. The citation before the court was issued on March 28th this year at 4:15 in the morning. You were operating a 2021 Volkswagen black in color on 10 Mile Road, entering Woodward Avenue in the city of Royal Oak. And at that place and time, you were cited for improper lane usage with an accident. Officer Cole's remark appearing on your ticket indicates Unit 1, which would be the Jetta, turning from westbound 10 Mile Road onto southbound Woodward, attempted to change lanes from middle lane to outer lane, sideswiping Unit 2. That is the citation before the court. You do have three options. You may admit responsibility, Mr. Bruner. You can admit and explain, or you may deny responsibility and the court will swear the parties and take your testimony. What do you wish the court to do for you?
I would like to admit and explain, Your Honor.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak, and at that place and time, you used your lane improperly and made contact with a second vehicle, correct?
Yes, Your Honor.
Thank you. Court accepts your plea. What would you like the court to know?
I prepared a statement, Your Honor, if that's okay
Right.
if I read that. Okay.
Sure.
So, Your Honor, I want to plead guilty and take responsibility for the accident and the lane change violation that resulted in an accident. I understand that I made a mistake and I've taken it very seriously. I respectfully ask the court to consider leniency because it's my first traffic citation. I've maintained a clean driving record for the past 8 years. I'm currently a nursing student and I work very hard to maintain a good standing, both academically and personally. This incident was not intentional or reckless. It does not reflect my normal driving habits. I've also learned from this experience, and I respectfully ask the court to consider reducing any penalties or points if possible.
Fair enough. Thank you for your remarks and your preparation, Mr. Bruner. Officer Cole, what would you like to shoot?
A motion to amend to impeding, Your Honor.
Very well. Impeding traffic, Mr. Bruner, is a 0-point violation. will not appear on your master driving record. So if that is acceptable to you, the court, very well. The court will assess the fine. So there's a fine and there's an accident fee. So your grand total today, Mr. Bruner, is going to be $220. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within, well, I'm going to mark this 21 days.
Okay.
And that completes your hearing. Please be careful out there.
Yep.
If we don't always obey those traffic code provisions, we can end up being our own patient in a healthcare perspective. Okay? Good luck to you.
Yeah. Thank you, Your Honor. Thank you, officer.
Case number 26, RO 01860. This is People versus Kara and Estasia Polk. That's you?
Yes.
Kara Polk, today is the date and time for your informal hearing. You were present earlier when the court explained the nature of an informal hearing, correct?
Yes.
So you understood the court to instruct that you must select from one of three options to protect your rights, yes?
Yes.
Thank you. The citation before the court was issued April 1 this year at 8:05 in the evening. You were operating a 2012 Toyota silver in color on Main Street at or near Harrison in the city of Royal Oak. At that place and time, you were cited for exceeding the posted speed limit by a minimum of 1 to a maximum of 5 miles over. Officer's remark that shows on your ticket indicates defendant driving southbound Main from Harrison, front moving radar 45 in a 30 zone. So the margin of speed, at least in the officer's estimation with the instrument, was considerably higher, but Officer Cole chose to write this for 1 to 5 over. Regardless, today's your day in court. You may admit responsibility, you can admit and explain, or you may deny responsibility. The court will swear the parties and take your testimony. What do you wish the court to do for you?
I'm gonna say I'm not responsible.
Very well. Please raise your right hands. You both solemnly swear the testimony you shall give before this court shall be the truth.
Yes.
Yes.
Yes? Thank you very much. The officer testifies first. She's got the burden of proof today. Ms. Polk, and then it is your turn. Officer Cole.
Your Honor, I'm going to be completely honest. I did not receive a subpoena for Ms. Polk today. So I
Okay.
did not have any ample time to print out her ticket or prepare anything. I did not receive a summons for her.
Very well. So you don't have any comfort level to give any testimony today.
No, Your Honor.
All right. And in the absence of that, you have not at least made a prima facie case. So at this time, Ms. Polk, the court is going to find you not responsible.
Okay.
All right.
What does that mean? I'm good.
That means you're as they used to say, off the hook. However, the court would remind you that the traffic code is simply a safety regulation for everybody's benefit. So please be careful out there. It's particularly a dangerous driving season, especially with the motorcycle people coming back up. Okay, good luck to you.
Thank you so much. Have a great day.
Good morning once again, everybody. It is TCF Live on a Wednesday. Good to have you all here. Things are starting to kick off now, but still a little bit slow. So we're going to continue to ride with Magistrate here for 1 or 2 more cases.
Calling case number 26, RO 01715. This is People versus Jamarika. Ramsey, that's you?
Yes, sir.
Good morning, Ms. Ramsey.
Good
Welcome to
morning.
44th District Court. This is your informal hearing. It is not a criminal matter. Nobody goes to jail today on this ticket, but it's serious enough that Officer Cole issued the citation on the date in question. That date was in fact March 28th of this year at about 20 minutes of 1 in the morning. You were operating a 2017 Land Rover gray in color on 13 Mile Road, Gator near Woodward. At that place and time, it was discovered your vehicle plate had expired a couple of days after Christmas.
Yes.
So you have three options. You can admit responsibility in this matter. You can admit, explain, and display an updated registration, or you have every right to deny responsibility. The court will swear the parties and conduct your trial. What do you wish the court to do for you?
The second option, admit responsibility and show updated registration.
Okay, so on the date in question, you were operating a motor vehicle in the city road with a tag that had expired on December 27 of 25, correct?
Yes, correct.
Thank you. Do you have your updated registration?
Yes, Your Honor. It's listed somewhere on here that it's for the Land Rover.
A little bit, okay. And that looks like it was acquired in April. So the only suggestion the court would make is get that decal on your plate ASAP.
Yes.
Okay. Any motions?
Motion to dismiss, Your Honor.
Thank you. This one is dismissed. Ms. Ramsey, you're a very young person. A couple days after Christmas every year for the next 70 years, you're going to need to get your license plate updated. Good luck to you.
Thank you, Your Honor. Have a good day, you all.
I think I've exhausted your motorists.
Your Honor, I have Officer Plitz here next up for you. All
Terrific. Thank you.
right, have a good day. Thank you.
If we're being completely honest, he didn't just exhaust the motorist. I think he exhausted that officer as well. She looked bored as hell. We'll come back to the magistrate. Let's go down to Lake County, Ohio, and say good morning to Judge O'Donnell.
Guilty to count 3 of the indictment, that being possession of heroin, a felony of the 3rd degree, in violation of ORC 2925.11. Should that plea be forthcoming, it's the state's further understanding that the defense will request the appropriate reports and the matter will be deferred for sentence.
All right, Mr. Patterson, is that correct?
Yes, Your Honor, but the other charges, of course, would be dismissed.
Right. All right, Mr. Davis, how old are you?
34,
How far did you go through school?
1 year of college.
Are you a U.S. citizen?
Yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no, Your Honor.
Have you ever been diagnosed with or treated for any mental illness?
No, Your Honor.
Did you get a copy of this indictment?
Yes, Your Honor.
All right, and so it's my understanding you're pleading guilty to count 3, possession of heroin, a felony 3, and then the remaining counts will be dismissed at the time of sentencing. Is that your understanding?
Yes, Your Honor.
All right.
One other thing, Your Honor, the prosecutor indicated he would remain silent at the time of sentencing.
Okay, is that
As
right?
far as sentencing. But he said, does he tell you that?
My understanding is that the defendant will defer to the court in terms of fashioning a sentence, or that
You
the
mean the
state
prosecutor?
the state will defer to the court in terms of fashioning a sentence.
All right. All right, Mr. Davis, before I accept the guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Patterson some more, let me know, and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you could be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes, Your Honor.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, Your Honor.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
In count 3, possession of heroin is a felony 3. It carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, Your Honor.
The fine in this count is mandatory. The minimum is at least $5,000 up to $10,000. Do you understand that?
Yes, Your Honor.
And also with regard to this count, there's a presumption that a prison sentence should be imposed as when it comes time for sentencing. And you must overcome that presumption at the time of sentencing, or a prison sentence must be imposed. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Are you presently on post-release control to the parole authority?
No, Your Honor.
Do you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, Your Honor.
You understand your felony conviction prevents you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If the violation of post-release control is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand that if a prison term is imposed in this case, you are eligible for judicial release?
Yes, Your Honor.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand at the time of sentencing, I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk to Mr. Patterson before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions at this point?
No, Your Honor.
All right. Ms. Naroda, if this case went to trial, what would the evidence show?
Your Honor, had the state proceeded to trial with respect to count 3, the state would have brought forth the following facts that demonstrated on or about August 6th of 2025 in Willoughby Lake County, Ohio. The defendant was in possession of 5 grams of heroin, a Schedule I controlled substance. The facts were this, Judge. The Willoughby Police Department on August 6th utilized a confidential informant to make telephonic contact with the defendant to a number attributed to the defendant. As a result of that phone contact, arrangements were made between the confidential informant and the defendant to meet in Osborne Park and conduct a drug transaction. At the time of that transaction, the defendant was taken into custody and found to be in possession of the 5 grams of heroin. The heroin was sent to the crime lab and determined to weigh just that, 5 grams, and to be Schedule I controlled substance.
All right, Mr. Patterson, anything to add to those facts?
No, Your Honor, at this time. I've reviewed all the videos, I've reviewed all the statements, and this is exactly what I was forwarded to when I was given the discovery by the prosecutor's office. That it happened on August 6, 2025, and it was a controlled substance, and it was 5 grams. I believe that was when it was tested, it was 5 grams, yes.
All right, Mr. Davis, did you hear what Ms. Naroda said, that the facts would show if the case went to trial?
Yes, Your Honor.
And are those facts true?
Yes, Your Honor.
All right, what is your plea to count 3, possession of heroin, a felony 3?
Guilty.
Your Honor, we'd like to get a forwarded copy of these. I'm sure we will.
Thank you, Dave. For the record, Judge, I am handing you the written plea of guilty. It has been signed by Mr. Patterson and the defendant, Mr. Davis, as well as myself on behalf of the state. That document was previously provided to the defense counsel, and the state's understanding they had an opportunity to review it before coming on the record.
All right, Mr. Davis, is this your signature on this written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
All right, I will accept the written plea of guilty. Defendant was present. Mr. Patterson advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept the plea of guilty and find him guilty of count 3, possession of heroin, a felony 3. I'll refer this for a pre-sentence report. Sentencing will be June 24 at 1 p.m. And the bond is continued. June 24th, 1 p.m. The bond is continued. Anything else, Ms. Naroda?
I'm sorry, did you say a pre-sentence investigation and did you say a drug and alcohol?
Just pre-sentence.
Just pre-sentence, okay. Nothing further, Judge.
Mr. Patterson, anything further?
No, thank you, Your Honor.
All right, we're adjourned.
Thank you, Judge.
It's TCF Live. Nice to have you all here today. To our new friends, good morning to you as well. Barbara, thank you for the $10. Calls out Tot, says there's a late fee for members only. The fee is $10. I've got this one covered for you. Todd immediately sasses back, well, you've been late a lot lately. Did you pay your fee? And then Barbara responded with 5 gifted memberships. So I'm assuming that was to cover her late fees. And Wahoo, thank you for gifting a membership. So I appreciate all of you so much. Let's go. Judge McNally. Let's go there.
In your house? In a fenced-in yard? Or on a leash, accompanied by a suitable adult and equipped with a muzzle. Do you understand it? Yeah.
next to dog.
You did?
Again, 5 days after the incident.
And this is the same dog, correct?
Yes.
Do you have any other dogs?
I do.
What kind of dog?
She is a Staffordshire Terrier.
Do you have any dogs, Kimmy Sherrill?
No.
All right. I'm gonna give you both a personal bond, $500. You cannot leave the state without the consent of the court to violate a law. You must appear in court as directed. My court officer is going to take the file to the prosecutor, and you can go out in the hallway, and the prosecutor will call you and as she's ready. Okay? Any questions, either one of you, ma'am?
No.
Ma'am?
No.
Okay, good luck. Thank you. All right, Boris Torres. Brandon Johnson, 26B1501988. Good morning.
Good morning, Judge. Beyond POV 8237 contact Mr. Johnson stating.
Sorry, what's up?
All right, so we have a charge here of resist and obstruct. As I understand it, he's going to plead guilty to that charge, correct?
Correct. Under 7711.
Right. He's also going to plead guilty to the possession of a controlled substance charge under 7411, and then the prosecutor is going to dismiss the expired plate. True?
Yes, Your Honor.
Is that what you want to do?
Yes, sir.
If you plead guilty to the possession of a controlled substance charge, that is punishable by up to $500 under local ordinance, fines 500, costs 90 days jail, or all of those. The same holds true with regard to the resist and hinder and obstruct charge. I'm going to take the drug charge under 7411. I'm going to take the resist and obstruct charge under 771.1. I'll place you on probation after you come back for sentencing, and if you're compliant at the end of the probationary term, the case would be dismissed. Both of them would. You understand that, sir?
Yes.
So I'm essentially, all right. Did you sign, read, and understand the advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to plead guilty?
Yes.
To the charge, resist, hinder, and obstruct an officer, how do you plead?
Yes.
To the charge, possession of a controlled substance, how do you plead?
Yes.
Were you in the township of Brownstown on February 1 of 26 at 1:57 in the morning on I-75 near Sibley?
Yes.
And were you in possession of a controlled substance, and if so, what and how, what kind of drug?
Yes, it was 2 ounces column pills.
All right, you did not have a prescription for those. Where were they? On your person?
Yes, sir.
In your pocket or what?
Yes, sir.
And what did you do to resist, hinder, and obstruct an officer?
I didn't pull over until enough time.
I'm sorry?
I didn't pull over enough time. I didn't see the officer.
So the officer was following you, his lights were oscillating, siren on, and you didn't pull over?
Yes, sir. It was 2 o'clock in the morning. There was police flying by me. I didn't know he was pulling me over. I came up off my exit to go home, and the officer was still behind me, and I pulled over, and that's when they said I was taking too long to pull over.
Is that the reason they wrote him?
I'm sorry, Judge, I didn't hear you.
I'm sorry, I'm looking at this. It says the officer attempted to effectuate a traffic stop. The defendant continued traveling southbound on I-75, exited I-75, turned on the westbound West Road, continued through Buda, through Fairway. Was the officer following you the whole time?
I'm not sure, sir. All I know is.
Well, you're making it sound like you don't think you did anything wrong, and if that's the case, that's fine. I don't want you pleading guilty to anything. Did you know the officer was was pursuing you, and did you continue to flee and elude the officer intentionally? Yes or no?
No, sir.
Okay, then you can set it for Yeah, we'll set it for trial. You can have a seat and we'll figure out when the trial date's gonna be, okay? Thank you. Have a seat. Raymond Lawrence Winter II. 26B150596. Your name?
Raymond Lawrence
You're
Winter.
charged with malicious destruction of property. You have the right to an attorney. Would you like one?
Yes.
All right, we're gonna set you up with a lawyer and we'll go from there, okay? Defense lawyer. All right. Detroit Disposal, 26UO24058A and B and C. Okay, good morning.
Good morning, Your Honor. George Howell appearing on behalf of Detroit Disposal. I have full authority from my client to resolve this matter on their behalf. I have met with the township attorney and we have come to an agreement whereby on the weight charge, we'll pay a flat fines and costs of $1,000 and in exchange also dismissal of the 2 defective equipment charges.
Okay, and you're authorizing that plea on behalf of the defendant, true to overweight?
Yes, Your Honor.
To that charge of overweight violation, responsible or not responsible?
Responsible, Your Honor.
Okay, I'm gonna accept your plea. I'm going to go ahead and assess fines and costs on that of $1,000 that they can pay by June the 20th. And then I'll go ahead and dismiss the other charge of defective equipment. Both of those charges of defective equipment as set forth in files B and C. Okay?
Very
Have
good.
a great
Thank you
day.
very much.
Thank you
Your
very much.
Honor. You too. Thank you.
People against Vladislav Sirchuk, 26 B150808.
Good morning, Your Honor. For the record, Gregory Slodopolsky, P41-341, appearing on his behalf. Your Honor, have authority to plead responsible to one added count of distracted driving, local ordinance violation. We ask the court to accept the plea and give my client 10 days to pay fines and costs.
What's he do for a living? Is he a NASCAR driver?
Your Honor, I appreciate the question. I do not know. I saw the ticket. I was puzzled. His parents are more than puzzled. His parents are very upset. So hopefully this was a learning experience for this young man. He's 19 years old.
Yeah, he's driving like a maniac, 96 miles an hour. To the charge of distracted driving, responsible or not responsible?
Responsible, Your Honor. When they're 19, they're not thinking straight. So
Accept the plea, dismiss the speeding on motion of the prosecutor. 190 is going to be his total, and he's going to pay that by May the 27th, okay? 190 by May the 27th.
got it. Thank you so much, Your Honor.
Have a good day.
You too, Your Honor.
Okie dokie, friends. Good morning once again. Let's go down to Florida. Wade Mercer, say good morning there.
You've been charged, arrested for 1 count of disorderly intoxication and 1 count of resisting an officer with violence. Mr. Dougall is here on your behalf. I read the complaint. Mr. Dougall, any input do you want me to be aware of, sir, or any argument?
Judge, I would question the probable cause because if you go through it, the officers are there. Mr. Pandya is clearly the owner of the hotel. He's clearly listed as being in the office at that time. So I don't know how he would be out among the public being able to, which is one of the requirements of disorderly intox. There's a presumption that he was intoxicated. I have no idea if he's suffering from some other type of medical problem during that time period. That was never established. And then it leads from that to the resisting an officer with violence. If Mr. Pandya, once again, they keep saying that the lobby's open to the public. If he's the owner, he has the right to close that, lock that at any time he wants. And that appears to be from the complaint affidavit of what he did. So, I just question the probable cause. And then on the resisting with violence, just because you stand there in a, I guess, offensive position, I don't know if that makes the requirement of resisting with violence. I don't believe there was actually violence done in order to make it with violence. at that time. And then same as too, as if that was the case, you can certainly resist an unlawful arrest if they're not at that time. So that would be my arguments on that. I know it's going to be brought to your attention because Mr. Mitchell was nice enough, along with Mr. McDaniel, to let me know that Mr. Pandia had been arrested. So I'm just kind of here as a courtesy to Mr. Pandia and the court, just because I do represent Mr. Pandia on a pending DUI case. I know that will be brought, and I know Your Honor probably is already aware of that. So I would ask the court to take that into consideration too, because I know the court's normal policy would be to revoke the bond on the DUI case. And I would ask the court to take the lack of probable cause on these new charges and not do that on Mr. Pandia's behalf.
Thank you, Mr. Douglas. Thank you for being here on behalf of your client in the misdemeanor case. Mr. Mitchell.
Yes, Your Honor. I'll start with as it goes to the disorderly intoxication. I'm looking at the jury instruction when it comes to that follows the statute when it comes to that. It says in this situation, state must only prove the following two elements beyond a reasonable doubt. One, the defendant was intoxicated and he or she endangered the safety of another person or property. In this situation, there's allegations that Mr. Pandia was intoxicated based on the indicators, and that he was actually trying to get into room 215, where there were actually people in that room that law enforcement collected statements from. And even if he may own the hotel, he has no right to go into the room unless there's like extenuating circumstances when it comes to that. People would have like a reasonable sense of privacy when it comes to their own hotel room. And the other part of it says the defendant was intoxicated or drank any alcoholic beverage in a public place in or upon a public conveyance, and he caused a public disturbance. The complaint alleges that Mr. Pandia was being very loud. He was standing up, exposing his genitals with his pants around his ankles. While he was showing all these signs of intoxication. Additionally, as for the resisting part, he was actually standing inside the doorway and holding the front door shut in an attempt to prevent law enforcement from entering the public accessible lobby. And then that's when they got in and started, he started gesturing and throwing his fist up in a bald manner. We would contend that there is probable cause for the charges here. And as a result, and there's also signs showing that he violated condition of his bond in the DUI case, which was no alcohol. I believe based on the circumstantial evidence here, he was under the influence of alcohol. So given all that, we would ask the court to find probable cause and move to revoke his bond in 26108 CT. Is that what you said? 103 CT.
Okay, so I read the complaint a couple of times. I think Mr. Doug will make some excellent points. I don't disagree with Mr. Doug. I don't disagree. I think he probably can close the lobby anytime he wants. And I'm not sure that anything in the lobby would amount to disorderly intoxication. The problem is, from my perspective, the part of the complaint that says that causing a disturbance on the balcony area and disturbing the peace and quiet of the motel guest. That was according to a guest. That is probable cause for disorderly intoxication. And this resisting with violence statute says resist with violence or offering or threatening to do violence. That's probable cause for that charge based upon the fighting stance. That doesn't mean they're going to prosecute you for that. The state will make that call. But for probable cause purposes, threatening to do violence does meet the definition of the statute. So I'm going to set your bond in the two new charges at $5,000 on the disorderly intoxication, $10,000 on the resisting. I am revoking your bond. You're out on bond. You have a condition, no alcohol. I'm revoking that bond in case number 26103 CT. You've got no bond in that case. So Mr. Pandia, even though you have a bond set in the new charges, there's no point trying to post it. You're not going anywhere because you're out on bond. You have been arrested with new charges. There's probable cause, and you have a condition not to possess or consume alcohol. So I'm going to ask the state to give me an order revoking his bond for, there's probable cause to believe both of those, the new charge and the possession or consumption of alcohol. Mr. Pangia, where that leaves you, sir, is you've got a court date coming up with Mr. Dogle. That court date will stay the same unless Mr. Dogle and the state agree to a different court date. You also will now get a separate court date for a felony case that you've not hired Mr. Dogle in yet. Should you hire Mr. Dogle in that case, this court date may change. I'm going to ask the jail to give you the court date notice for right now, which is June the 2nd at 8:30. Again, if you hire Mr. Dogle in a new case, or if you hire any attorney, that court date may change, but right now that's going to be your court date. Mr. Dogle, thank you again for appearing. Anything else from your perspective today, sir?
Judge, I would ask one question. You know, Mr. Pandia did have a offer on the DUI case that consisted of probation.
I wouldn't accept the probation offer. I wouldn't accept the probation offer given at this point. I'm not saying I wouldn't accept it a week from now, but today I would not accept the probation offer I wouldn't accept that. I think that wouldn't be appropriate, but I'm not saying I wouldn't accept probation at all. I want to give the state time to look at it. I think there's a good chance this comes back and becomes resisting without and disorderly intox, and we can resolve everything at one time, Mr. Dogle. So a week from now, it may be a probation off on everything, but I've got to give the state time to look at that new charge. I think you make some excellent points. It's not your traditional resisting with violence, even though I think it may meet the statutory definition for probable cause. So Mr. Pangia, Mr. Douglas is going to do what he can to try to see if he can get that case moved to misdemeanor court and try to resolve everything at one time. I don't want to take the probation plea that was offered to you, and then the state transfer these new cases to a misdemeanor. And then I'd rather just wait and wrap everything up at one time. And plus, I don't have a problem at all with you being in jail based upon the complaint I've read. Mr. Douglas, anything else today, sir?
No, Judge, I think I've put everything I could on the record.
I think you've done a great job. Thank you for being here. I think our clerk has a question. Yes, ma'am. It'll stay the same unless Mr. Douglas moves it to a different day. So once Mr. Douglas speaks with Mr. Mitchell about what's going to happen with the new case, I may see him next week. Actually, I won't see him next week because I won't be here, but I may see him the week after next to resolve everything if the state decides to handle the new charges as a misdemeanor. Thank you for pointing that out. So if the court date stays the same as what you've already got him set for, Mr. Douglas, we need to know that we got to connect to the jail on that event. So please let the clerk's office know if you're not going to move it up. And I don't think you can really make that call until you see what Mr. Mitchell's office does.
Right. I'll try to talk to Mr. Mitchell.
And just to be clear,
Mr. Pandia.
Thank you. Mr. Pandia, just to be clear, I think Mr. Douglas' argument, I think he's got an excellent argument that you don't have a disorderly intoxication case inside that office, because even though it may typically be open to the public, as Mr. Douglas argued, I'm not aware of any reason you can't lock that door anytime you wish. A lot of hotels that are run by one person, they may go to the restroom and lock the door and come back out from the restroom and unlock the door. I think that's a pretty good argument. The problem is the stuff that allegedly happened on the balcony. That's why I'm doing what I'm doing today. But thanks again, Mr. Douglas.
Thank you, Your Honor. I appreciate you hearing me out.
Yes, sir. Have a good day, Mr. Pandia.
Thank you.
We do have one more person that has friends or family here today, and that is Mr. Johnson, Marcus Johnson.
Thank you, Your Honor. You have a good day.
Take care, Mr. Douglas.
I'll be in touch with you, James.
Mr. Johnson, good morning. And if y'all work something out, I'll be here the week after next. Mr. Johnson, you're here because you've been accused of one count of possession of cannabis with intent to distribute, possession of marijuana over 20 grams, and third charge, possession of drug paraphernalia. Your grandmother and your auntie are in the courtroom this morning. Mr. Johnson, I've read the complaint. There is probable cause. I've also looked at your criminal history, which only showed one charge of possession of firearm on school property on a school trip. And that case was dismissed last year. That's the only thing I see. So I'm going to listen to the attorneys and I'm going to address your bond status. Mr. McDaniel, anything on behalf of Mr. Johnson?
No, Your Honor.
Mr. Mitchell.
We just request that you be subject to random UAs.
Mr. Johnson, I'm going to set you the normal bond I would set for these charges. Your bond's $5,000 on your 2 third-degree felonies, $2,500 on the misdemeanor. Your total bond is $12,500 cash or surety. You do have a condition of random urinalysis as part of your bond. Mr. McDaniel, I was kind of on the fence on a conditional release offer or not. I decided not to offer conditional release primarily because, well, two reasons. The prior arrest It's concerning, but it was dismissed. But the other reason is the sheet I've got from the jail says he's 20 years old with no job. So let me verify that. Mr. Johnson, are you employed anywhere?
No, sir, I go to Chipola for welder.
Okay, that's good. I didn't know that.
He
You got
was-
full-time, Mr. McDaniel, go ahead.
I was gonna say, Your Honor, he was pretty honest in it, and I don't want to call him out here in front of everybody, but he was pretty honest and pretty, acting, at least that he was ready that he got caught, I suspect, but he was pretty honest about it.
Mr. McDaniel, the last time when he had him last year, he was set a cash bond. Is he asking for a cash bond alternative in this case?
Yes, Your Honor.
Mr. Mitchell, any objection to a cash bond?
No objection.
So the equivalent of a cash bond for that particular bond would be, let me go back to my notes here.
1,250, I think.
Yeah, $1,250 cash. So ladies, he's going to have a cash bond just like he had last year. That case was dismissed. But his cash bond is $1,250. Just like last time, if this case is dismissed, that $1,250 will be returned to whoever posted it. If this case is not dismissed and there's court costs and fines ever imposed, then that $1,250 is taken and put towards court costs and fines under Florida law. So instead of having to go through a bondsman, his bond is $1,250 cash. He's got a condition of random urinalysis, and the judge will give him a notice for his court date, which will be June 2nd. June 2nd at 8:30 will be his court date in front of Judge Garcia. Do you ladies have any questions? Any other questions? Mr. Johnson, do you have any questions?
No, sir. Mr.
Mr.
Mercer.
Johnson, wish you the best.
Yes, sir.
Thank you, ladies, for coming. That's it for friends or family, Mr. McDaniel. So we can go back to the next on the list, which is Willie Mack. Mack, good morning, Mr. Mack. You're here because you've been accused of one count of failure to register a motor vehicle. Mr. Mack, there is probable cause for the charge. And I'm going to appoint the public defender's officer to represent you, Mr. Mack. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Mack, we're going to plead no contest to charges listed, 10 days in the county jail, $400 fine, 1 day jail credit. If you plead guilty, that will resolve this case today. He's waived his right to jury trial and call witnesses. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Mack, did you hear that agreement, sir?
Yes.
Mr. Mack, do you have any questions about that agreement?
No, I don't think so.
And sir, is that the plea you would like to enter?
At this time, yes.
Mr. Mack, I'm going to accept your plea of no, excuse me, no contest, failing to register a motor vehicle and driving it on the roads. I'm going to adjudicate you guilty of that offense, sentence you to 10 days in jail, give you credit for 1 day that you've served. I'm imposing the court costs and fines of $400, and they'll be reduced to a civil judgment if you don't get them worked off. Mr. Mack, I pulled your driving record because when we had you last year, it was habitual driving a license suspended or something. I just want you to be aware, there's a pending suspension that's in there. You have a valid license now, but according to the driving record, the state of Florida has notified you that you have a suspension that's about to take place that has something to do with insurance. So when you get out, make sure you got your driver's license straightened out before you drive anymore. I was very pleased to see that you got them back after your last court date, but you're about to lose them again. So make sure you take care of that when you get out before you drive. Mr. Mack, do you have any questions?
Was my motorhome towed?
Listen, I was there driving it home for you.
No, I want to find out what it was told to you.
Talk to the sheriff's office.
Yeah, whoever did, let's see if it was Sheriff's Department case or if it was FHP. I think this might have been an FHP case. Yeah, it was Florida Highway Patrol that did the crash investigation. So that's who you would contact. You or your friends or family would contact the Florida Highway Patrol to find out, to answer that question. The complaint doesn't tell us that. All right. Wish you the best, Mr. Mack. We have Todd Clark next. You think sometimes they give you a toe slip? I didn't know that. Mr. Clark, good morning. Mr. Clark, you're here for first appearance accused of 4 counts of felony petty theft. Mr. Clark, there is probable cause for these 4 charges. Mr. McDaniel and Mr. Mitchell, the information has been filed by the state. The information adds a 5th charge of organized scheme to defraud.
I just saw that.
I contacted the clerk's office this morning and asked if Because normally when that information's filed, the clerk will issue a warrant on that fifth charge. And I wanted to make sure there wasn't going to be a warrant issued later because I want to go ahead and first appear on everything while I can. And they checked with Mr. Gill, and then they notified me and said the state was not requesting an additional warrant. They felt like the bond on these 4 was going to be sufficient to ensure his appearance at court. So you've got 5 charges been filed against you, but only 4 of them were on the warrant that was before the state actually filed the information. So I'm going to go ahead and set you a bond in these 4 cases. Mr. McDaniel, anything on behalf of Mr. Clark?
Judge, just that, he's probably not working right now, but he's got advanced throat cancer, and I think he's trying to look for some treatment options now. So, going to see what happens. I don't know if he can post a bond.
I can't.
That's all right. All right. Thank you. And Mr. Mitchell, anything on behalf of the state?
No, Your Honor.
Mr. Clark, you have a very extensive criminal history, and I mean very extensive. Your bond's going to be $5,000 each on these 4 charges. Your bond today is $20,000 cash or surety. You have a condition to have no contact with any Walmart after today until this case is over with. So, Mr. Clark, you'll get to use the phone in a few minutes, sir, to try to post that bond. If you post it, you'll be released. If you're not able to post the bond, Mr. Clark, then the public defender's office will be in contact with you at the jail. The jail will give you a notice for your court date, which should be June 2nd at 8:30. Mr. Clark, do you have any questions?
So it's, how much money?
Okay. The next case is David Moore. Mr. Moore, good morning. Mr. Moore, you're here because you've been accused of 1 count of driving under the influence, 1 count of failing to register a motor vehicle, and 1 count of attaching a license plate not assigned to a motor vehicle. There is probable cause for these charges, and I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to Mr. McDaniel.
Your Honor, we just asked for a bond. He does work on the offshore boats, and so he's working. We just asked for some kind of bond.
So under employment on the jail sheet, the pretrial release sheet is just left blank. So tell me about your job, Mr. Moore. Where do you work at, and how long have you been there?
I work on a long line commercial fishing boat. I've been there about 4 months for Jerk Seafood out of Orangeport, Florida.
Do you have any charges pending anywhere?
No, sir. I just got out of prison about a year ago.
Okay. You're not on any probation, correct?
No, sir. Nothing.
Okay. I think you're entitled to a bond. Mr. Mitchell, anything from the state?
We just request that he not possess or consume any alcohol while on bond.
Thank you, Mr. Moore. The speed you were allegedly going at while you were under the influence, to the extent your normal faculties were impaired, allegedly was 116 miles per hour. Your bond's going to be $5,000 cash or surety on the DUI, $2,500 on the other charges. Your total bond is $10,000 total cash or surety. You do have a condition not to possess or consume alcoholic beverages while this case is pending. So you'll get a chance to use the phone in just a few minutes, sir, to try to post the bond. If you post it, you'll be released. If you don't post it, we'll see it on an upcoming jail arraignment docket. Your court date, if you do post bond, will be June 1st at 9 a.m. The jail will give you a notice for that day. If you don't post bond, we'll see you a few days after that. You have any questions, Mr. Moore?
No, sir. That's it.
Have a good day, sir. After Mr. Moore, we have Leonard Lunsford. Mr. Lunsford, good morning. Mr. Lunsford, you're here because you've been accused of 1 count of driving while license suspended or revoked knowingly. Mr. Lunsford, there is probable cause for this charge. I've also looked at your criminal and your driving history. So your criminal history is not bad. Your driving history is. I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, and he's going to tell me where we need to go from here. Mr. McDaniel?
Your Honor, we just asked for a bond.
Mr. Mitchell?
That's from the state, Your Honor.
Mr. Lunsford, I'm going to set you the normal bond I would set for this charge, which is $2,500 cash or surety. You've got a condition not to drive a motor vehicle without a license. If you get your license issue straightened out, you drive all you want if you can afford the gas. But I know I stay at home a lot nowadays. But Mr. Lunsford, if you get caught driving without a license, sir, that will violate your bond. So make sure you don't do that. You'll get a chance to use the phone in a few minutes to try to post the bond, Mr. Lunsford, and the jail will give you a notice for your court date, which should be June 1st at 9 a.m. Mr. Lunsford, any questions?
No,
Wish you the best, sir.
thank you.
Yes, sir. Mr. McDaniel, I think Mr. Mitchell has one thing, and I know I've got one statute I want to talk to y'all about. But as far as anything on the record, Mr. McDaniel, anything else on behalf of the Public Defender's Office?
No, Your Honor.
And Corporal, anything else from the jail today?
No, sir.
Officer Whitkerson, thank you. And Mr. Mitchell, anything from the state?
Nothing as it pertains to first appearances.
So ladies and gentlemen, if you
Alrighty, friends, that brings his docket to a close. Good morning once again. Hour one pretty much in the books for TCF Live on this lovely Wednesday. Going to take us up to Michigan, Judge Simpson. I'm going to step out of the studio for a couple of minutes and grab some breakfast. Grandma TCF made wonderful blueberry muffins yesterday, and Ellie kept me so busy this morning I never got to eat breakfast. So I'm going to go warm up one or two of those, and I'll be right back with you shortly. But in the meantime, here's some Judge Simpson for you.
Live between this Office of the Public Defender and support matters. However, if one does lies, we will wait.
All right. In the court for its part also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Julia Blevins.
Your Honor, Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Julia Blevins.
Your name?
Julia Blevins.
I have before me a plea form that indicates that the defendant will be pleading as charged to retail fraud second degree, the 1 year. Upon her successful plea, well, she's agreeing. Not, I think I'm up a line. You're not agreeing to dismiss anything. The defendant is agreeing to $789.74 restitution. Is that right?
Yes, Your Honor.
All right. And also there's a sentence agreement to a prosecutor's deferred sentence.
That's correct, Your Honor.
Yes, Your Honor.
On. Where we go?
Oh, did I forget?
Counsel's signature.
Sorry.
No, it's Mr. Cook's fault. Is that yours? I pick a person each day. I'm going to blame for everything. So.
Very well.
All right. May I have her sworn?
Right. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Julia Blevins.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any question regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights that are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
On December 24th, 2025, at the location of 3145 Ann Arbor Sleen Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at Meyer that makes you think that you're guilty?
I loaded like items into a cart and I walked out past the point of
Put merchandise in your cart and tried to walk out of the store without paying?
I did walk out, yeah.
Pardon?
Yes, I did walk out.
Okay, you did walk out of the store. All right. And your intent was to steal that property?
Yes.
Store was open to the public at the time?
Sorry, what?
Was the store open to the public at the time?
Yes.
Do you have anybody's permission to take that property?
No.
And this property you took was the property that was offered for sale by Meyer?
No. I mean, yes.
Okay. Was the aggregate amount or the total amount of the property in excess of $200?
Yes.
Yes. All right. Ma'am, I do have to apprise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge, date 20. Okay.
Yes.
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
At 12.
June 24th, 2026, 12 noon. Bond will continue. Ma'am, stop down at my probation department on your way out and schedule your appointment. All right? Thank you. Court calls the case, People versus Russell Norvell.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Russell Norvell.
Your name, sir? Russell Norvell.
Your Honor, I have been speaking with Mr. Cook. We would just be asking for one more adjournment. Mr. Norvell and I have just been going over discovery and we're trying to figure out a resolution.
The last adjournment on this matter.
June 3rd.
Adjourn the matter June 3rd, 2026, 9 a.m. Bond continued. That's an in-person hearing.
Your Honor.
Thank you. Court calls the case of the People versus Jacob Simmons.
Your Honor, Raymond Cook. For the people.
Carolyn Foster Tucker on behalf of Jacob Simmons.
Carolyn Foster Tucker. Allen. Your name, sir? Jacob Simmons. All right.
And Your Honor, we would also be requesting an adjournment in this case. I've been speaking with Mr. Cook and we're trying to resolve the case.
June 3rd, 2026, 9 a.m. In person. Okay. Bond continued. Thank you.
Thank you, sir.
Court calls case People versus Carla Bristow.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Alexander Hermanowski with and on behalf Carla Bristow, who's appearing by Zoom. Carla, please state your name for the record.
Carla Bristow.
All right.
Your Honor, this
Thank
is
you.
time and date set for
Go ahead.
This is time and date set for pretrial. I just got in contact with Ms. Bristow this morning. I was appointed on this case earlier this week. And she does not have a discovery packet yet. So we're going to be asking for an adjournment so she has a chance to review that, as well as giving me an opportunity to try to figure something out in this case for a resolution. So we're asking for a brief adjournment.
I had before me a plea form. Is that?
So, Your Honor, I believe when the public defender had this case, there was going to be a plea.
Got it.
There was another pending case that may impact that. That case is in review. Charges were declined on that case. But
Mr. Hermanowski hasn't seen everything.
Correct.
All right. I'll adjourn the matter June 3rd, 2026, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Bond will continue.
Back in the studio, my friends. If you can see down in the lower left corner, this is my breakfast. 2 blueberry muffins cut in half, warmed up, buttered, yummy. Thank you, Grandma TCF. Let's get back to court.
Not sure.
Brooks? They're not here.
Your Honor, I texted numbers from the pre-sentence report because he was being sentenced before Judge Conlon. And I represent him on 2 probation violations there. But I also talked to his lawyer on one of his cases before Judge Conlon, Miss Maribel, and she's supposed to send me, okay, she did just now send me a number for his mom. So I'll try and call his mom. Thank you.
calls the case, People versus Rebecca Bryson.
Morning, Your Honor, Raymond Lawrence Winter II.
Howard Burdell on behalf of Rebecca Bryson.
Your Honor, good morning, Dan Garrett. We filed a substitution listing the public defenders. Exactly.
Third substitute. Go ahead.
Two attorneys, one case. Ms. Bryson, can you unmute and identify yourself?
Yes, I just did that.
Your Honor, as indicated, we filed a substitution. We did it with the public defender's office, unaware that Mr. Burdell had been appointed. We filed another one this morning. Got it. Burdell's signature on it.
Okay. All right, what are we doing?
I'm asking for a final settlement conference, please.
And no objection to the Mr. Garen's motion, of course.
Jury final settlement conference is 5th and 8th,
Yes.
June 5th, 2026, 9 a.m. Jury selection if necessary, June 2026, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you, bond continues. Court calls case People versus Naval Krieger.
Good morning, Your Honor, Raymond Lawrence
Good morning, Your Honor. Christina Saxon from Ms. Peters. It's great to see your name for the court, please. For your Honor, I'm asking for an adjournment. The prosecutor's office was able to just send me some additional discovery a few minutes ago.
Turn the matter June 3rd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case People versus Franklin McDonald.
Morning, Your Honor, Raymond Lawrence Winter II.
Good morning, I represent on behalf of Mr. McDonald, who's approaching the court. Can you state your name?
Franklin McDonald.
Thank you.
Judge, can we get a final settlement conference date?
Absolutely. Jury final settlement conference will be set for June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Court calls case People versus Gregory Peterson.
Morning, Your Honor, Raymond Lawrence Winter II.
Good morning, Your Honor. Ken Thompson appearing on behalf of Gregory Peterson. Gregory, could you state your name for the record?
Greg Peterson.
Your Honor, today's date time set for arraignment pretrial. We waive reading, stand mute to the charges.
And having waived formal reading, standing for the court will enter a not guilty plea.
Your Honor, I have had a chance to speak to the prosecutor in this matter. We would ask for a first and very likely last adjournment. I think we're close to working this case out. Have received discovery yesterday from the prosecutor. Haven't had a chance to go over it myself and with my client.
June 3rd will work for you.
June 3rd would work.
3rd or the 17th, whichever.
The 3rd would be great, Judge.
Turn the matter June 3rd, 2026, 9 a.m. And also, so that council's aware, normally the civil infraction would have gone before Judge Barr. I've taken the civil infraction for convenience sake.
Thank you, Judge.
And so I'll adjourn that also to June 3rd, 2026 at 9 a.m. As the defendant's bond in this case, sir, I'll just set your bond at a $5,000 personal recognizance bond. Standard conditions, including no assault behavior, possession, weapons, and or firearms, no alcohol, recreational marijuana, or any illegal drug. All right. Thank you.
Thank you, Judge. Good
seeing you. Court calls case People versus Rita Bryant.
Your Honor, Raymond Lawrence Winter II.
Yes, Your Honor, Assistant Public Defender Buckovich on behalf of Ms. Bryant, who should be appearing via Zoom.
I am here trying to figure out how to get my camera. Sorry. Okay. There we are.
Okay. State your name, please.
Rita Bryant.
Thank you.
Your Honor, I'll be requesting an adjournment. Mr. Cook indicated that he had some media discovery. He just needs to fill out a media notice and get over to my office.
3rd, 2026, 9 a.m. Bond continue. Thank you, Ms. Bryant.
Thank you, Your Honor.
Court calls the case People versus Aaron Burrows.
Raymond Cook for the people.
Ron Brown appearing on behalf of Aaron Burrows.
You here?
Yes, I am, sir.
All right. State your name.
Aaron Burrows.
All right.
I'm requesting adjournment, Your Honor.
Turn the matter June 3rd, 2026, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case People versus Paris Callaway.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Terrace Callaway.
Good morning, Paris Callaway.
All right. What are we doing?
I'm requesting an adjournment after June 4th. He has a hearing on June 4th, which may give us direction in this case.
He has a hearing with
D-Lad.
D-Lad. 17th.
Yes.
Turn the matter June 17th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank
Have a
you.
good day.
You do the same. Court calls case People versus Nicole Coleman.
Your Honor, Raymond Cook for the people.
Coleman,
Nicole Coleman. I'm here. Nicole Coleman.
thank you.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Ms. Coleman. I believe Ms. Coleman will be working with our mitigation team, so I'll be requesting an adjournment for that to be done.
Turn the matter June 17th, 2026, 9 a.m. Bond continued. Thank you, ma'am.
Thank you.
Court calls case People versus Brian Culver.
An Assistant Public Defender Nicholas Bukovich on behalf of Mr. Culver, who should be appearing via Zoom.
Sir,
Yes,
state your name.
Brian Culver.
Before me a plea form, is that what we're doing?
That is correct, Your Honor.
Plea form indicates that he's going to plead to retail fraud 3rd degree to 93-day, which is as charged. The defendant is agreeing to pay $25.61 restitution, and the sentence agreement of the prosecutor's deferred. That's the court's full understanding.
That's correct, Your Honor.
That's correct, Your Honor.
Sir, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes,
All right, state your name again, please.
Brian Culver.
Sir, it is this court's understanding you're going to plead no contest to the charge of retail fraud 3rd degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased if 3 times the value of the property. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes,
All right. Do you understand what a no contest plea is?
yes,
All right. 2 things about it I have to make sure that you understand. One is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
yes,
Second thing is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
yes.
Basis for no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
Guilty.
Really?
No.
Meaning you're pleading no contest?
Oh, no contest. Sorry, sir.
All right. You understand that by pleading no contest, you will not have a trial of any kind?
Yes,
All right. You signed an advice of rights form or had one signed on your behalf?
yes.
Do you have any questions regarding any of those
No, sir.
rights? You understand that you'll be waiving all of those rights?
Yes, sir.
Sir, is there a problem? You got it? All right. Sir, you understand that you're waiving your right, waiving all of those rights? My apologies.
Yes,
All right.
That wasn't to you, Mr. Culver.
Yes, I wasn't raising my voice towards you. My apologies to you, sir. All right. Sir, you understand that you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today to get you to plead?
no,
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will.
Yes.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 24-19616. Any objection to the court having reviewed that report?
None from people?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court determined defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of the plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 24th at 12 noon.
June 24th, 2026, 12 noon. Bond will continue. Do I have probation intake? I do. Sir, I'm going to ask you to remain online. We're going to put you into a breakout room with my probation department so we can start the sentencing process, okay?
Okay.
All right. Thank you.
Thank you.
Alrighty, everybody. It's Wednesday here at TCF Live. Judging by the stats, there's probably some new people out there. Feel free to say hello to us in the chat. We are a very friendly folk here. You have stumbled into one of the best communities on YouTube, led by a guy who stumbles over his words. You can't do any better. Todd, you gifted a membership earlier, and I forgot to thank you for that. That's like twice in a row where I've been slow to thank you. So thank you, and thank you again, just for good measure, because I keep being slow with regards to that. Let's stay in Michigan, but let's head up to Ingham County, the Lansing area, to the new favorite of this channel, Judge Aquilina.
This is docket 261639FH and 261635FH. People of the state of Michigan versus Ruben Martinez. Counsel, your appearance is for the record.
Good morning, Your Honor. Sarah Brunner, Assistant Attorney General for the people. Good morning, Assistant Public Defender Sarah Donnelly on behalf of the defendant Ruben Martinez Jr., who is standing to my right.
Thank you. So please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and nothing but perjury? You put your hand down. Get great time done, so we're not talking over each other. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
Not at all.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had no time to speak with your attorney?
Yes.
And are you a U.S. citizen?
Yes.
And are you gainfully employed?
No.
When was the last time you were employed?
I'm self-employed.
What did you do?
Carpenter.
So you are employed, you just don't have any business
I'm
right
in
now?
jail, so I'm just.
Okay, when you're out of jail, are you working steadily?
Probably, yeah.
Well, it's either yes or no, probably doesn't count in my book.
If I have work, yes, I'll be working.
Okay. So I understand there's a plea, this is a child support case.
That's
so-
all, no.
Huh?
No, I'm not working.
Okay. I had you at an address in Tennessee.
Yes, ma'am.
You were extradited here?
No, I turned myself in.
Oh, thank you. And is that Valley Creek Road still current?
Yes,
And
ma'am.
who lives there with you?
It's my father's house. I rent from him. And my 6-year-old child.
Who's not part of this case?
Right, I have custody of my own child.
Okay, are you receiving child support in that case?
Yes, ma'am.
Okay. And on behalf of the people, what is the plea agreement on each file?
Your Honor, on each file, he's charged with 3 counts of failure to pay child support. He'll be pleading to count 1. We're dismissing count 2 and 3 on each file.
Then further, on each file, looks like on 261635 FH, needs to pay restitution in the amount of $8,530.21. Is that the balance of child support owed?
Yes, as of today, Your Honor.
So that's child support, okay? And then on the other file, needs to pay $14,350.09.
That's correct, Your Honor.
Okay, and then is this a continuing obligation?
Yes, Your Honor.
All right, thank you. Now, that being said, counsel, is that full, fair, accurate, and complete?
It is, Your Honor.
Sir, is that full, fair, accurate, and complete?
Yes.
And counsel, are you waiving reading of counts 2 and 3 on each file?
Yes, Your Honor.
As to reading the felony information, count 1 on each file, you may proceed.
The people of the state of Michigan versus Ruben Martinez Jr. on file number ending 1635 in the city of Lansing, county of Ingham, state of Michigan, on or about the dates of October 1st, 2021 through February 28th of 2022, sir. Count 1, child support failing to pay, did not pay support for his child in the amount or at the time stated in an order entered by the Ingham County Circuit Court in file number 2009-001175 DC, contrary to MCL 750.165. This is a felony, 4 years and or $2,000 fine. In file ending 1639, people of the state of Michigan versus Ruben Martinez.
You gotta slow down, ma'am. You're gonna wear out my court reporter first case this morning.
I'm sorry, Your Honor. People of the state of Michigan versus Ruben Martinez Jr. in the city of Lansing, county of Ingham, state of Michigan, count 1, on or about the dates of October 1st, 2021 through February 28th, 2022. In the city of Lansing, county of Ingham, state of Michigan, count 1, child support failing to pay, did not pay support for his child in the amount or at the time stated in an order entered by the Ingham County Circuit Court in file number 2018-003670 contrary to MCL 750.165. This is a felony, 4 years and or $2,000 fine.
Thank you. Sir, did you understand what was just read?
Yes, ma'am.
So on each file, you have 1 count of failure to pay child support. Each are punishable by 4 years. In 1 file, you have an arrears of $8,530.21, which you agreed to pay, which, by the way, is the law. And so if you continue to not pay, that number will grow. And hopefully you've arranged or will arrange payment with the friend of the court so that you're continuing to pay as well as pay down that arrearage. And then in the other file, you have $14,350.09, and you're aware of all of that.
Yes.
All right, thank you. Looks like you signed the advice of rights form on each file. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes, ma'am.
And if you had any questions, your attorney was able to answer those in regard to your rights?
Yes, ma'am.
Do you have any questions about your rights in this court?
No, ma'am.
And you understand that if someone forced, threatened, coerced you, promised you something, we would have made a record of, you need to tell me that now, because if you come back later and say you shouldn't have applied, I don't have to accept that and allow you to withdraw your plea?
Yes, ma'am.
Are you pleading of your own free will on each file?
Yes, ma'am.
And you're doing that after you've spoken with your attorney?
Yes.
And you've been satisfied with the representation of counsel?
Yes, ma'am.
And you understand you are also giving up your right to a bench trial or jury trial, holding the people to their burden of beyond a reasonable doubt, losing the ability to cross-examine any witnesses and evidence, present evidence and witnesses on your own behalf, and choose to remain silent or testify. You understand you're giving up all of those, including the automatic right of appeal you would have if we went to trial, as well as, and that would be on each file, but now you have to ask permission of the Court of Appeals if you wish to appeal. And you are only going to be granted that if the Court of Appeals agrees with the importance of your issues. You understand all of that?
Yes, ma'am.
Thank you. Sir, as to docket 261635 FH, count 1, child support failure to pay, how do you plead?
Guilty.
As to docket 261639 FH, count one, child support failure to pay. How do you plead?
Guilty.
Sir, you understood, that you needed to pay child support
Yes.
and you failed to pay.
Yes.
All right, and is there any agreement as to whether or not there's any upfront jail or any other?
Any what jail?
Any upfront jail?
There's no agreement.
Okay, all right, very good. And so let's turn to docket 261635 FH specifically. It's fair to say that under docket 09117 DC, you were ordered by the family court judge and the friend of the court to pay child support. Is that a yes?
Yes.
And while you may have paid something, you accrued arrears because you didn't regularly pay. Is that fair to say?
Yes.
And right now that arrears is $8,530.21,
Yes, ma'am.
including other amounts that you're regularly supposed to pay. Is that fair to say?
Yes.
Okay. And turning to 261639 FH. Well, let me just go back, sorry, I kind of jumped ahead. On the 261635 FH, this occurred in the city of Lansing, County of Ingham, State of Michigan,
Yes.
and that was, doesn't have an address here, but that would have been payable at the friend of the court, that would be 303 West Kalamazoo Street.
Yes, ma'am.
And that's the same on 261639. This occurred in the city of Lansing, County of Ingham, State of Michigan. Again, at the 303 West Kalamazoo address.
Yes, ma'am.
And on the 261635 FH, you failed to pay between the periods of October 1st, 2021, and actually because count 2 and 3 were dismissed, I'm simply going to say it's October 1st, 2021 through August 31st, 2025, because I believe the amount encompasses all 3 counts, even though he's only pleading to 1. Is that acceptable to both counsel?
Yes, yes.
And then on the 261639 FH file, again, you failed to pay between the dates of October 1st, 2021 through July 31st, 2025. Counsel again, you're stipulating it encompasses all 3 date ranges. I put it into 1 because all 3 counts were considered, and that's where the $14,350.09 comes in.
That's correct. That's fine.
And so you agree with all of that in both files?
Yes, ma'am.
All right, and on this 1639 file, that relates specifically to docket 18-367 DM. You had children that you were ordered to pay for through the friend of the court and the family court judge, and you failed to regularly pay. Is that a yes?
Yes.
All right. On behalf of the people on either file, any additional questions? I kind of put them together, which I don't usually do, but it's really the same factual basis, just different files and children and numbers.
No, Your Honor, the people are satisfied. Defense is also satisfied.
All right, thank you. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor. No.
This court comply with court rule?
Yes, Your Honor. Yes.
Thank you. On each file, I find defendants. Actually, I didn't even ask you. Did I ask you to plead yet? Did you plead to these?
Yes.
Okay. Sorry, got ahead of myself a little on. All right. I find each plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea in each file. Therefore, count 1 on each file will enter. Counts 2 and 3 on each file are hereby dismissed. However, just noted for the record, counts 2 and 3 are actually incorporated in count 1 because of the nature of the offense. If there's any outstanding warrants related to either file, those are hereby recalled and dismissed. Through sentencing date? June 26th at 10 a.m. Does that meet with your schedule, counsel?
Yes, Your Honor.
Yes, Your Honor.
All right, sir, you'll have to make an appointment with probation. That number is 517-483-6100. We're going to give you, I think it's a purple sheet and it has that number on it. I don't know how long you're going to stay here. We'll talk about bond in a minute. But if they don't interview you before you leave, you need to call them. If you do not, bench warrant will issue, we will extradite you, and then you'll pay for a whole lot more costs. So you need to meet with probation. Now, if I in fact allow him to go home, a couple of things are going to happen. Before you make your motion, let's be very clear on what those things are, because if they're not going to happen, we have work over at the jail. He can be available on Zoom so he can save the cost of travel and put that toward his arrears. He must be employed and be part of a work seek program, not commit any crimes. No alcohol, no drugs, etc. If those are agreeable, I'm willing to entertain bond. If they're not, he can sit in jail and judicious for all I care.
Yes, Your Honor. No, that's very acceptable to the defense. If you'd be willing to reduce his bond, he doesn't have any money to pay. So, and like he stated, he does have the children he needs to support as well as the one he has full custody of. So whatever the court would want, he's fine with complying with it.
On behalf of the people, what would you like me to know?
Your Honor, the bond has already been set down to about 10% of the arrears from the 25% that's mandated by the statute. He hasn't paid in some time, so I would object to it being reduced to PR bond.
Well, let me ask you this. How are you expecting him to pay the money if he's incarcerated and taking up tax dollars that we all pay for?
I understand that, Your Honor. He wasn't paying when he was out, so he's already shown us that he's not going to pay when he's out.
Well, I have a bigger hammer because he can go to prison. So then he doesn't raise his 6-year-old. So he's got a lot to lose because I'm not a judge who's going to tolerate this, but I'm also not a judge who's going to impede him and ensure that he goes to prison by not paying and by having the people pay for his, 5 minutes of fun and choosing not to wear a condom. What do you think about that, sir? How many kids do you have?
3.
This file reflects 3 children between the 2 files?
The 2 files is 1 each, and I have the custody of the 3rd
1 each. Do you see these children?
I did until I'm working on it.
No, you explain that to me. What does working on it mean and what does I did mean?
So I didn't want to keep getting in trouble with the first 2 mothers, so I backed off and focused on my 6-year-old.
Okay, what does that mean, keep getting in trouble? Is there some criminal history you want to tell me about or what?
No, well, with my ex-wife, the second mother of my child, it was too much.
You didn't have a good relationship?
We didn't get along.
Okay, so I understand that. But then when was the last time you saw the child?
It's been a few years. Ever since actually she didn't like my 6-year-old being born, so she basically just made it almost impossible.
Well, no, you made it impossible. I want to get this really, really clear because these cases I don't like.
Yes,
They
ma'am.
should not be in front of me.
I agree.
You chose to have a child.
Yes, ma'am.
The Constitution says that you have an absolute right, if you're a fit parent, to raise your child. So you have a right to go to court,
Yes,
ask a judge for help and say, the mom's not willing to see my child.
yes, ma'am.
And in fact, if it gets so bad, you might get custody of these children because she has an absolute obligation. You both have an absolute obligation to facilitate a positive relationship between the child and the other parent.
Yes, ma'am.
So it's on you that you have not seen your children and decided to not pay.
Yes.
Child support is the right of a child and an obligation of the parent. I'm not smart enough to come up with that language. You know what? That is tried and true, written by the Supreme Court over and over and over again in thousands of cases, and it also is based in Constitution. So the only one that sat on their rights is you. Those children have a right to the mom and the dad. But you just can't have your 5 minutes of fun and then ignore the children because us taxpayers pay. Somebody's been paying for those kids. And now we're paying more because you're housed in our jail. We don't want to pay for your fund. So what is it going to be? You're going to be a dad, or is she going to meet somebody and someone else is going to raise your child, because parental termination is alive and well. You don't see your child for 2 years. You don't pay for your child for 2 years. And the law says mom can come in and say, he doesn't care. I'm marrying someone else. Let him adopt. Is that what you want?
No, ma'am.
Well, then prove it to me, sir. I deal in evidence, and prove it to your child. You have a lot to make up for, to both children. When did you see the other child?
It's been a long time.
What's a long time?
10 years.
Do you have an dad?
I do now, yeah.
What does I do now mean?
Well, he wasn't around when I was a child. I mean,
Okay,
I grew up in a violent home.
okay, so he wasn't around when you were a child. Do you see this history repeating itself?
Yes, I do.
Now you are doing that to your children.
I
How,
understand.
so you know how these children feel and you don't care?
No, I do care.
How?
That's
You
why-
abandon them.
Well, that's why I turned myself in, so I could take care of this and get back to them.
Better late than never, sir. Who is taking care of the 6-year-old that you have in Tennessee?
My father,
And where's the mother of that child?
she's here in Lansing.
Does she see the child?
No, she doesn't want to.
You have a lot of different choices that you need to make in your life. Choose better women, choose your children over your fun and everything else you're doing. And you have to work, sir. So tell me about your work. How are we gonna get you to work?
Well, I'm very good at what I do. Like I said, I'm a carpenter and maintenance man. So the reason why I turned myself in is because I was going to get a job. I got employed twice, but the background checks did not check out because of the felony backgrounds, and it was good paying jobs.
Okay. Maybe that was the wake-up call you need. But I'm also certain the prison can use a good carpenter. So you decide to not pay. And your children will find you in the list of MDOC.
Yeah, I don't want that.
And let's fix this problem, sir. Have you talked to the friend of the court about how much you're supposed to be paying?
No, I tried to get a hold of them before I turned myself in, but I never got a return call.
Well, I don't think you tried very hard because they're accessible. You have a cell phone?
Yeah, I did.
Did you leave them a number? Do
Yes,
you know
ma'am.
who your caseworker is?
I forgot her name.
Well, here's how it goes, sir. You have to pay child support plus an additional amount every month or bi-weekly, however they've ordered you to pay. The regular child support plus an amount for the arrearage. And they set that now. If there's been a change of circumstance, they have you at too high of a wage or too low or whatever, they can adjust that, but they will only adjust it back to the date you request. So if whatever they're collecting is too much, you need to let them know, because they will not retroactively credit you. They do not allow you to sit on your hands and then it becomes their problems. If you want to invoke your rights to see your children or to have your child support go up or down and accurately be reflected, then you have to take action.
Yes.
All right, sir, how are you going to get back to Tennessee?
Fly. That's my father
Your dad's going to help you?
to get back there. Yeah.
All right, sir, I'm giving you a $30,000 PR bond. I want you working. You'll report to pretrial services as directed, as often as directed by telephone, since you can't do it in person, you're going to be in Tennessee. You shall not use any illegal drugs, alcohol, marijuana. If you have any, you will show a prescription to pretrial services. Do you have a history of drug abuse?
Yes, ma'am.
And how recent is that?
I'll be 2 years clean and sober in July.
All right, so you'll PBT and or drug test as requested by pretrial services, law enforcement, any court officer, your father, or mother of any of your children?
Excuse me.
Repeat that one, last one.
Yeah, he will PBT and or drug test as requested by pretrial services, law enforcement, any court officer, your father, or the mother of any of your children. So we can make sure you're clean and sober during your parenting time. If it's positive, we'll do a secondary test and we'll see if it's a false positive or a positive positive, and then we'll take whatever action we need. You will not own, have in your possession, under your control, any weapon, gun, ammunition, imitation of a weapon will not be in the presence of any third party who has those. Do you have any weapons in the home, guns?
No, ma'am.
Good. You will not be in the presence of any known gang members or any known felons. You'll not wear any gang colors, insignia, or gang tattoos. You will maintain your current residence, and any address change will be reported to pretrial services, the court, and your counsel within 24 hours. You will appear before this court on Zoom at 10 a.m. June 26, 2026. Now, and that's at 10 a.m. If you want to be next to your attorney, you'll have to come all the way back to Michigan, but I'd rather see those funds pay your child support, but it is your right to stand next to her. How we do it on Zoom is that I would put you in a confidential breakout room and you can talk to her that way. If that's okay with you, we'll proceed that way. Otherwise, I need your body physically here in front of me like it is today. What is your preference?
No, that's okay.
Zoom?
Zoom, yes, ma'am.
Very good. You shall be employed and shall not be, and if you're not employed, you shall be part of a work seek program, and you will not give any employer any cause to terminate you'll advise the front of the court and circuit court and pretrial services of all employment. How much time do you need to get gainfully employed?
A month.
A month? How are you gonna pay your bills during that month?
Within a month, right?
Within a month.
I guess that.
I gotta get back to Tennessee. It could be less than that.
Well, let's just say it will be less than that. I don't care if you work at Taco Bell or Burger King or Aldi's or whatever. You're gonna work until you get some other employment. And I don't want to hear that you're being paid under the table because that is another felony, state and federal.
Okay.
All right, so you'll be employed within 30 days of this order. You also will follow all family court orders in Michigan and Tennessee. Anything I failed to add on behalf of the people?
No, Your Honor. No.
Have I been clear?
Yes, ma'am.
Any questions?
No, ma'am.
Hold the key to the jail or prison, sir. You pay? Or you get one card?
Okay.
It's up to you as to what kind of dad you want to be.
Yes, ma'am.
Just going back off the record.
Thank you.
Oh, wait.
All right, friends. So I agree with pretty much everything that Judge Aquilina had to say there. But I disagree with one thing, and I'm going to get on my soapbox about something else because I always do in these cases. The one thing she said I don't agree with when she said the front of the court is accessible. Now, for those of you who aren't familiar with how Michigan works, FOC, the front of the court, is the arm that handles child support matters and family court kind of matters, visitation, parental rights, stuff like that. They're the most inaccessible organization pretty much on this planet. Think of the worst government organization you've ever dealt with, multiply that by 10, and that is the front of the court. I speak this through personal experience. My first wife and I lived in Michigan. When we separated, our children went with her for physical custody. We both had legal custody, but that meant I was paying child support. And good luck getting any response whatsoever out of front of the court. You can go there, sit in their office all day long, and they will ignore you. I actually had to go through legal angles to finally get them to hear me at one point. So I don't want to hear that part from Judge, but I agree with all of the dressing down that she gave that guy. The other thing that I will get on my soapbox for, and I always do with these cases, I get it with the non-custodial parent and the whole you need to pay your child support, 100% on board and agree. But I will say again, the system needs to be fixed. The custodial parent needs to be able to account for how that money is being spent, and they're not required to. So the judges can get on the high horse about how the non-custodial parent needs to support the child, and I 100% agree, but they need to be equally holding responsible the custodial parent to make sure that that money is funneled through to the child's needs. And so often it is not. And I find that to be a pathetic hole in the system that nobody does anything about. Nobody bats an eye to what's going on with that money once the state hands it over to mom or dad or whoever has custody, and that is just plain wrong. All right, off high horse. Thank you for listening. Let's go to Judge Yeah, let's go to Judge DeSanto. Say good morning to her.
Eligible for district court, treatment court, because it's felony.
No, I understand. Now, Mr. Bresnahan asked that you take the plea and send it out for sentence. And that's why I just wanted to alert you so I wouldn't surprise you.
No, I do appreciate that, but the language should probably be changed to just be circuit court, treatment court, not district or circuit court.
And that's perfect. Although they already accepted him in Dearborn, county prosecutors accepted that court as the option.
Wait, what?
He's already been accepted into the Dearborn treatment court and the county prosecutor said that's good. So I don't know, change whatever you want.
Well, no, I'm not changing it because that's not my agreement.
We'll address that.
Okay, well,
I
yeah.
just didn't want to
If you wanna-
blindside you with a plea tomorrow.
No, I appreciate that. And I still am unclear as to why district courts accept circuit court pleas when they just go right down there anyway. But in any event.
You can hold it for a moment.
Yeah, right.
Okay, and then,
Yeah.
Next week we'll bring you some more disgusting Lincoln Park cases.
Well, but the thing is that, well, there's a few things. One, if he's been accepted into the 19th District Court Treatment Court, it's my understanding that's it's district court, so it would be a misdemeanor. Do they know that he's pleading to a felony?
Yes, they do.
And they can accept, that's interesting.
I did one also in the Westland court a few years ago. And they did the same thing. This is not frequent with me. Usually you just write district court misdemeanors, but Mr. Bresnahan accepted this one and he said it's fine. And I'll address those concerns before trial. Yeah.
I understand that that's fine with him. My confusion is that a district court treatment court is accepting a felony.
I understand. It's beyond my bandwidth. I don't understand.
So, right, so you may want to just confirm that they understand that it's a felony and it's not being reduced to a second or a misdemeanor before everyone's moving forward. And then also, if that's not the case, then the district court has to be, the district court provision on here has to be removed.
But I don't mind crossing it out, Judge. That'll be sorted out by somebody paid much more than I am. So.
Well, no, it has to be sorted out before the pleas.
No, we'll do that tomorrow. I'm gonna let Mr. Bresnahan know when I leave for today. If he's fine with that, because they've already accepted him. Judge, I think there might be something else. He's an employee of the city of Dearborn. They put him in the employee assistance program, so the court may have accepted him irrespective of what the plea is. I'm notified, Mr. President.
Well, right, but just for the fidelity of their program, they need to make sure that
Judge, I agree.
other people are,
May I approach, because he dropped something here on the floor that's slightly important.
okay.
And I just didn't want you to get surprised tomorrow morning, so go ahead.
I appreciate that, but you should check with 19 District Court to make sure they realize that that's a felony, and then I guess go from there.
I sure will, Your Honor.
Okay.
Thank you, Judge.
Okay, thank you. Okay, so Alicia, whenever we need a break, you just go ahead and wave the flag or
Okay.
good morning. Oh, I'm in blues and whites too. Okay, I know, trying anyway. Okay. So are you good with doing the Zoom with this breakout rooms with the attorneys and everything, Alicia?
I
Okay. Okay, so then you just let me know, do you have the docket there, Dade?
You didn't get one?
No, sir, I did not.
Get you one.
Okay. Mr. Serrano's not in here.
Did you need a docket?
I do, please. But that's okay.
I did two, I guess, that this one's not spaced out, is that?
Yeah, no, that's what I like. Yeah. Okay. That's this. This is not spaced out. How many pages is this? Is this 2 copies?
Nope, that's.
Go.
6 pages? We have a 6 pages today?
Yeah. Yeah.
Because
Because mine is spaced out like that, maybe.
Oh, okay, sorry. Okay, so this is double spaced. This is probably with the new system. Okay, that's fine. That's less crazy. Because otherwise it's just a single space, but in any event, that's still a lot of cases today. Okay. Okay, Mr. Serrano. You already have St. Clair County checked in, St. Clair County Jail checked in?
Yes, but he has not spoken with DuBois yet.
Okay. What is his name?
His name is House. Sean House.
Okay.
And the other gentleman has not spoken to his attorney yet.
And who is the one in Wayne County Jail?
He is Justin Carlton.
Okay. All right, which I think Mr. Westmoreland has Mr. Shenke's cases today. Bobby, is that right?
Not all of them, Judge.
No, okay.
Some of them were assigned to other people.
Okay.
Are you looking for
Who,
Sean House?
that's Mr. DuBois.
Yes.
Mr. Carlton, who has Mr. Carlton?
Mr. Shrine.
Your Honor, but I understand you need to be in here for the other cases?
I do, but I didn't realize that you were on your way in to interview Mr. Carlton.
Whichever the court pleases.
Okay, well, we'll just handle, we'll handle Mr. Heisler first. Who has Mr. Selma? Who has Mr. Selma?
I do.
You do. Okay, we'll handle those two first. Okay. All right. All right, counsel, we're going on the record, so, okay. So let's go on the record in the matter of Billy Heisler, 24240.
Your Honor, good morning, Richard T. Serrano, P. 3828. Today, Your Honor, I appear on behalf of my client, Chris. This being the date time set for a show cause matter. Sir, please state your name for the record.
Billy Heisler.
All right, good morning, and thank you for, thank you. Thank you for dressing appropriately for court. And, counsel, today's date scheduled for a show cause in this matter. Your client has failed to pay his fines and costs in the amount of $2,869.51.
That's correct, Your Honor, and we've talked about that. He has $200 to pay toward that balance. In addition, he said, a couple weeks ago, was it, he said he tried to make $150 payment, but inadvertently, he sent it to the 25th District Court. They refunded the money, so he's here, but he's gonna make sure he makes the $50 payments in the future timely and to the right court, but he does have $200 to pay today. Is that correct, sir?
That is correct.
All right, sir. Well, let's see. You've been, why have you failed to make payments at all in the last year and a half?
That's not true at all, Your Honor. The only time I've failed to make payments is the last 3 months, I believe.
Okay, so,
I was garnished on my paychecks, so I have been struggling completely. And I tried to make the 3 months up with $150, but like my lawyer said, I accidentally sent it to Lincoln Park. I got that situated, and then now I have $200 to pay towards that.
okay,
I was paying the $50 a month. And then some months I wasn't able to. Natalie would call me, and then I would pay the $100 for the 2 months.
okay. So let me clarify a couple things, okay? First, if you're not able to make a payment, sir, don't rely on somebody here at the court to contact you. You should take the initiative to contact the court by email as to whether or not if you're able to make your payment. If you're unable to make your payment, and then indicate that you're intending to make that up the next week. There's no talking in court, please.
Understood, Your Honor.
So you're paying $200 today,
That is correct.
and how much per month?
$50.
And what date of the month do you pay your $50?
I don't have a set date to pay it. I was
Okay.
told to pay 30 days from the last time I paid.
Okay, so we're gonna pick a set date, so that might be a little bit easier to manage, and then that way you just know when it is. You don't have to worry about, oh, maybe I can do it this day, maybe I can do it that day. And then if you can't make it, that payment on that date that you've selected, email into the court, letting us know, I'm unable to make my payment today. I'm going to double up next week or next month.
Okay.
Okay,
Sounds good.
all right. And so what date of the month would you like to select, sir?
Middle of the month sometime, maybe the 12th let's say the 12th.
Okay, so beginning June 12th?
That sounds good.
Okay. Okay, you can stop at the window, sir, and then you already have the information about paying online because
Right.
you've been paying online, you paid the wrong one. Okay. All right, thank you. Have a good day. Okay, and we're on the record in the matter of the City of Wyandotte versus Michael Selma, 26601.
Your Honor, Richard P. Serrano, PHUA appearing on behalf of my client, appears on my right. Your Honor, this is the date time set for his pretrial. Sir, please state your name loudly for the record. Michael Selma.
Okay, and today is the date scheduled for the pre-trial counsel, as you've indicated. And you've had an opportunity to review this matter with the prosecuting attorney.
Yes, I have, Your Honor. In fact, I arraigned Mr. Selma. He's posted a bond, as the court can see. Yes, we've resolved the matter, Your Honor. My client will plead as charged. He's going to the controlled substance charge. He'll plead guilty as charged. We're asking that to be taken. So it's section 155.001. I've explained to my client what that means. He understands it. And if that plea is in fact accepted by the court, I think he qualifies for that ordinance section. The other charge of possession of paraphernalia would be dismissed on the prosecutor's motion. He's ready to sign his advice of rights, Your Honor. He's ready for the court's examination.
Okay, and so, sir, I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and you heard the plea that was placed on the record, correct?
Yes, Your Honor.
And as to the charge of possession of controlled substance, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand that by entering into a plea, you'll be waiving some of those rights.
Yes, Your Honor.
You understand as well the possible penalty as a result of your plea, whether this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
All right, counsel, if you can please avoid your client.
Mr. Selma, on or about May 8, 2026, approximately 1:30 a.m. Were you in the city of Wyandotte?
Yes.
You were in a motor vehicle, weren't you?
Yes.
And you had contact with the police, they stopped you?
Yes.
And upon the police officers investigating further and searching the vehicle and yourself, they found some drugs, turned out to be crack cocaine. You agree with that?
Yes.
You were the only person in the car, weren't you?
Yes.
So it was yours, correct?
Correct.
I'm satisfied, Judge.
The court is also, and you understand what the 155.001 status is, correct, sir?
Correct.
Okay. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to count 1, dismiss count 2 per the plea agreement. And sir, if you're to test right now, what's in your system?
Just marijuana, Your Honor. And no, I do not have a prescription, Your Honor.
When's the last time you used it?
It was about a week ago, Your Honor.
Sir, you were arraigned, you were arraigned 12 days ago, so that was more than a week ago, and this court instructed you, sir, not to possess or consume any alcohol or drugs that are not prescribed.
I meant to say more than 12 days ago. I wasn't being accurate with the days.
Okay,
I just meant a week ago as in before the convention. That's what I meant.
okay, so just for clarification, sir, since you've been released after your arrest, have you used any marijuana?
No, Your Honor.
Okay, very good. The court's going to order bond and conditions are continued, and you are currently testing, correct, sir?
Correct.
Okay, very good. And so you're going to go over to probation and you will get all of your next steps. Okay?
Thank you, Your Honor.
Thank you. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. We are on the
Hour 3 now of TCF Live on this fine Wednesday. Good to have you all here. Seriously, good to have you all here. This is like the best job in the world, is being here with you guys. So thank you so much. Let's go back to Judge Aquilina, new contestant there.
All right, this is docket 25369 FH, 23967 FH, 23969 FH. And 256131 FH, people of the state of Michigan versus James Clark Legion. Yes, okay, counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people. Thank you, Your Honor. Michael Anderson on behalf of Mr. Leggins, who does appear personally to my right.
And which routes are you on?
I am on the first two, Your Honor. So
967.
Yeah.
23969.
Yes, sir.
And then Attorney Goodrich is here. Are you here on the other two?
Yes, Your Honor.
All right, thank you. Appreciate that. Okay. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. You taking any medication yesterday or today?
Yeah.
Is there medication you're supposed to be on that you're not on?
Yes.
And not being on that medication, does that interfere with your ability to understand your attorneys or this court?
No.
And are you feeling okay today, sir?
Yes, I am.
All right. And any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to talk to both of your attorneys in regard to sentencing?
Yes, I have.
Have you reviewed the pre-sentence investigation report with them?
Yes, I have.
All right, thank you. And counsel, you believe he's oriented to date, time, and place, and does understand what's occurring despite having taken his regular medicine along with not having some of it. Is that correct?
I do, Your Honor, based on numerous conversations.
Yes, Your Honor.
All right, thank you very much. On behalf of the people, are there any corrections, additions, deletions?
Yes, Your Honor. Obviously, as it pertains to the 967 file that we're here for sentencing on, the attorney is Mike Anderson, not Luke Goodrich. And he is appointed. I'm sorry, he's retained, not appointed.
Thank you.
Those are all the factual corrections that I've had.
So I'm changing that on the basic information sheet. I'm changing the cover page, and let me see this other evaluation plan. Yes. To the first line. So then, Mr. Goodrich, are you here on the files that will be dismissed?
That is correct, Your Honor. Mr. Anderson will be making all arguments on behalf of Mr. Leggins today.
All right, Joe, is there any, I don't want to waste your time, you're certainly welcome to stand where you are, but is there any reason beyond this that you need to be here?
I don't believe so, Your Honor, but
Yeah, I appreciate you being here. Any objection to Mr. Goodrich carrying on with the rest of his cases?
Then I might. No, Your Honor.
All right, thank you very much
Thank
for
you,
your
Your
service, sir. All right. Sir, and counsel, did you have any additional?
I do, Your Honor.
Okay.
Just in information report under highest grade completed, it says unknown. That is 7th grade. And then under religion, it says unknown, that would be Baptist.
Where are you? And what page is that on?
Your Honor, right below highest grade completed on the basic information report.
Always. Okay. I'm sorry, what is it? Baptist?
That's on page 2 of the basic information report under jail credit, it says 247 based on the calculation that's later in the report. They have the end date of credit being May 19th instead of May 20th. So I believe it should be 248 instead of 247.
Correct, Your Honor.
Okay, and then change of the basic information sheet, cover page. Okay, and I also changed the outline.
Thank you, Your Honor. And then on page 15 of the pre-sentence investigation, under marriage,
Yes, sir.
it has his son as deceased. That is incorrect. He's live and well and 27 years old.
Good to hear that. Okay, and then again, under education, oh, he does say something great. Okay.
Yes.
Great.
And then under employment, on the exquisite soul food, it notes him as a cook. He was also a co-owner of that establishment.
Okay, and then he's been unemployed since 2018.
Yes, that's correct.
Sir, if you don't feel well, you can certainly sit down. I don't have any problem with sitting down. All right, is the chair still there?
I took it away, but I can bring it back.
Do you want it? Yeah, we don't want you to fall down, sir. Thank you. There.
That is all I had in terms of the basic information, Your Honor.
All right.
Judge, I had one other factual correction. If I may.
Yes.
I'm sorry. On the cover page under plea agreement, I just noticed this. It says amended plea, the defendant pled guilty to count 1.
Yes.
I think we best note that the defendant pled guilty to original count 3.
Okay.
Subsequently, count 1 entered. I think it's the best way, as I have 4th. And I will explain that in a moment.
Okay.
And Your Honor, I have no objection to that change.
Okay. Okay. Sir, you pled guilty to what ultimately was count 1, controlled substance, delivery, manufacture of controlled substance less than 50 grams with habitual 4, that is punishable by up to life. Do you recall that? Okay, thank you very much. And do we have any issues with the guidelines?
Yes, Your Honor. Mr. Henderson correctly indicates that OD 19 should be scored at 0, not 10 points.
OB 19 is 0?
Correct. That makes the total OD's point value 15
Change has been made.
and a level 2.
Change has been made on change in the basic information sheet. Council, are there any additional corrections?
The guideline range then goes to 10 to 46. Your Honor.
10 to 46, and we have defendant any additional corrections?
No, Your Honor.
We just changed the basic information sheet.
Also on page 2, the recommendations.
Okay.
The guideline range there as well.
I'm also changing that recommendation narrative. It says the 247, changing it to the 248 days. All right, then I think everything looks like it's consistent.
I'm sorry, Your Honor.
Something else?
I just caught this under page 1 of the pre-sentence investigation.
Yes.
And Mr. Berman can certainly double check on this. But my guess is where it says docket 23-00369 FH. Given that the offense date is July 18th of 2024, I believe it's docket 24-00369 FH.
I'm sorry, I'm not seeing what are you looking at the cover page or?
It is under additional information. Your Honor, can I briefly approach?
Yes.
Great.
There's so many pages to this.
Yeah.
I want to make sure you the right one. Oh, under additional information, okay.
And then docket,
Oh,
it says 23. I believe it should be 24.
I believe it is.
is it 23-369 FH or a different one?
That's not what I have. Twenty-five, 369 FH.
So it's the 23 should be changed to a 25. Is that what you're saying? Yes.
Yes.
That's, okay, got that. Okay. Right, and then can somebody, before we,
I'm sorry, where are you looking? Because where I'm looking says 25, 369 FH.
go to show them where, it's under additional, so we don't usually make, it's under additional information on page 1. It's the second paragraph from the bottom.
Thank you.
Yeah, that was a good catch. All right. I also see on the cover page that he has 2 civil infractions in, there's a no pickup because they're civil, probably in the range is too far away. There's 2 active warrants. Those been taken care of?
No, Your Honor, I became aware of them when I received this. I did double check the register of actions. They're traffic infractions.
Right, I figured
On
2023, so he probably just owes a fine plus late costs and all that.
Yes, sir.
Okay. All right. On behalf of the people, what would you like me to know?
Thank you, Your Honor. Originally, we were before the court, just by way of catching up on April 2nd of 2025. At that time, on this file, we entered into a plea agreement where the defendant pled to it on an amended information count 3 as an habitual offender 4th. I did that under a 1-year delay pursuant to MCL 771.1. And if the defendant remained bond compliant and had no new charges, the defendant would be sentenced on count 3 as I have 4 with no further upfront jail. I would dismiss all those other files and the remaining files or charges on this file. And then I said if the defendant, or the agreement was if the defendant is non-bond compliant or is charged with new crimes, count 1 shall enter as I have 4 with no sentence agreement, and count 3 that was added pursuant to that plea agreement would be dismissed. I did that because of the advocacy of Mr. Anderson. He actually got me feeling bad for Mr. Leggins, and I was provided with some health information for him and said, yeah, this is someone we ought to try to do something here. So let's do this. Let's reduce this. Let's not put him in our jail, and let's let him just for 1 year. That's all it's going to take is 1 year. Let him prove to us that he can get a job or volunteer his time or just sit in the house and watch TV. But for heaven's sake, let's stop with the drug dealing and having guns. And we didn't make it very long. At that point, we then had bond violations because he picked up the new file, that being the 256131 file while he was on the 1-year delay, where there was a raid at where he was at, and he was sitting on a bed with a bag of dope on the bed and other items in the room that oddly enough also contained the medical information that had previously been provided by counsel to get me to give him a deal. I then, instead of having him getting sentenced pursuant to the guidelines on this case with no agreement, still somewhat feeling for Mr. Leggins, we entered into this agreement where I'm going to say that he only does the 24 months. I've practiced in front of Your Honor enough to know that this court does not take kindly to drug dealers. This court does not take kindly to people not following the court's orders, and that situation for Mr. Leggins possibly could be a lot worse. I note in that new file that he got charged with law and bond. His guidelines, if I remember correctly, start, I think, at 70-something months. Today I was provided by counsel a packet from CMH with a treatment plan for Mr. Leggins. It appears as though he was ordered no bond by this court in September of 25. And then in December of 25, CMH came out and gave this treatment plan. And I think the prospect here is that even though there's an agreement that there's a fixed minimum of 24 months, Mr. Leggins would like to ask this court for some kind of treatment. Well, it's my position you can get that, Your Honor. At this point in time, I have McNally's for the dismissed files. 23969FH, I'm going to be dismissing another high severity felony delivery of less than 50 grams, along with possession by a felon of a firearm, possession of ammunition by a felon, and a felony firearm charge. And then in 25369, I'll be dismissing firearms, possession by a prohibited person, controlled substances, maintaining a drug house as an habitual offender fourth. And then finally in the 25131FH file, I will be dismissing the controlled substance delivery manufacture of methamphetamine, the controlled substance delivery manufacture of less than 50 grams, the weapons ammunition possession by a prohibited person, the weapons dangerous weapon possession miscellaneous, and the habitual offender fourth notice. The defendant has 9 prior felonies on his record. To think that he wasn't afforded some form of treatment or help at some point in time would be naive of us. So I'm asking the court to follow the agreement. The defendant has earned his 24 months fixed. He's earned quite a bit more, but that's where we're at. He has almost a year, getting close to a year of credit. And then he can do his time on parole and have a nice towel if he decides to continue with this. I don't see the problem here as Mr. Leggins being just a user and having a substance abuse problem. He's always caught with large quantities. There's always seems to be guns and ammunition nearby. Tells me he's a drug dealer. Tells me he's peddling drugs to the community. He's not working. He's not paying his taxes like the rest of us. And at this point in time, I think the message that needs to be sent is that he needs to go to MDOC. I'm sorry he has health issues. I'm sorry he appears in court today and has to sit down. I would suspect that the Michigan Department of Corrections has a much better system and is better equipped to treat and help Mr. Leggins with whatever issues he has. I'm asking the court, while it is a sympathetic situation.
While it is a situation?
I'm sorry. It is a sympathetic situation.
Thank you.
And he is 67 years old. He has earned this, and I'm asking the court to follow our agreement. Thank you.
So the question I have is the agreement was for a fixed 24 months. Were any of these violations after that agreement? Did he violate this agreement?
No, the new agreement we have with the fixed 24 is since he's been in jail. So
okay.
No, he has not.
That's correct, Your Honor. There haven't been any bond violations as he's been in custody. Your Honor, I know that you reviewed this pre-sentence report, and one of the things that you looked at is probably the lengthy criminal history of Mr. Leggins that spans multiple pages. I do want to draw your attention to that criminal history. And what you'll notice, Your Honor, is yes, it starts in 1983, starting with a larceny over 100, and moves on to 1985, 1988, 1991, where there's a controlled substance. And then we get to 2004 retail fraud, second degree. And what you will notice after those string of retail frauds, which as this court is very aware of, is very indicative of an individual with a substance abuse problem, is that you'll notice from 2004 until 2018, what we have is a gap outside of a few driving while license suspended, which were likely suspended due to his substance abuse problem. Now, I think that period of time is important because it does show that the individual that Mr. Leggins can be. During that period of time, he was married, he was employed. In fact, he owned a business as a restaurant owner where he also cooked, but also importantly, he did a lot of self-reflection as to his faith, and in fact was engaged as a pastor during that period of time. Now, what we see is after 2018, Mr. Leggins, my understanding is at that point in time, he went through a divorce. He then got involved with the wrong individuals and began using again. And so while Mr. Berman indicates that Mr. Leggins is a dealer, and yes, he is being sentenced for possession with intent to deliver. As this court is well aware, individuals often deal in small amounts in order to feed their habit. Now, that is what I believe Mr. Leggins was doing based on multiple conversations with him, based upon, at this point in time, over 2 years of representation and discussions with Mr. Leggins. What he's indicated to me is pretty much, Your Honor, he's too old at this point. He's too old to be doing this. He's too old to be using. He already has a plethora of health issues, diabetes, heart problems, just ankle problems, and the use of substances only increases that. So, Your Honor, the agreement is, in my view, what the agreement is. As the court was provided, Mr. Leggins did reach out to CMH in terms of setting out a treatment plan for him. That recommendation was for him to engage in inpatient treatment. But what I also note, and you will note in the pre-sentence report, is that during his incarceration so far, he is engaged with CATS in order to work on his substance abuse. So it's not as though Mr. Leggins has been sitting in the jail, being unproductive, not trying to engage in what his demons are, and his demons involve the use of illegal substances and legal substances, namely alcohol. So, Your Honor, I do want this court to be aware of, while we have this massive criminal history, what we also have is that gap of the individual that Mr. Leggins can be when he is clean and sober and away from, in my view, certain influences. Now, in a, what I'm going to call magical Christmas land world, we would get Mr. Leggins out of Ingham County into an inpatient facility like Bear River up north. But I do understand what the agreement is. I believe it's a fair agreement. But I wanted this court to be aware of the information and the context in terms of that criminal history.
Thank you. You are a zealous advocate, but what I see here is less than stellar despite the excuses he may have. Sir, what would you like me to know?
It's kind of hard to talk about. It's like I'm stuck between two hard rock in a stony place right now. I come from a large family. I come from 8 brothers and 4 sisters. And only thing left in my family now is 2 boys and 1 girl. All the rest of them passed on, and a whole lot of them passed on because I come from a family that used drugs a lot. That's how I got onto it. They introduced me as, like, at the 1975, my family, my brother and sister, introduced me to drugs back then. And I caught a habit of doing that all the time. My mother, father, they deceased. My father was an alcoholic. My mother had some type of dealing with drugs. You know, my whole family was, they call it dysfunctional family. As I was 15 and 16 years old back in 75, I was just tagged along behind them, what they did. You know, I see now that it was a bad choice I made. Probably behind my brothers and sisters the way I did. But seemed like everybody was doing that back then, you know, so I kind of tagged on behind them. In 83, I went to prison for retail fraud for I was stealing to maintain a habit. 2004, no, let me go back to 1990, 91, 58 of 94, and 9/16 of 96. My kid's mother moved to Colorado with me. And I only had a girl then. As she came along, we had another boy, then we had another girl. They diagnosed her with cancer in 97. A few months after my kid was born, they diagnosed her with cancer. And I ended up, we went together, but we just kept our kids together the most we could. And she ended up where she was so bad with cancer, they were giving her them patches on her chest. And she was getting a real bad drug habit. Her drug habit was so bad where she figured that she didn't want to be around her family no more. So she up and left me and the kids. I took care of the kids myself. I ended up having a drug habit myself, messing with her pain patches. And in 2004, Child Protective Agency came in and talked to me because the people next door to me had called Child Protective Agency on me. They came and talked to me and said, they didn't call me because it was a bad thing about you. You feel you need some help because you're trying to take care of your kids by yourself while you got a drug addict. So we're trying to help you right now. So you get anybody in your family, get your kids to until you get yourself better. I gave my kids to my niece. She just deceased last year in May. She took care of my kids until I got myself better. I ended up going to Eaton County Jail. I got a year in county jail with 90 days suspended upon completion of rehab. And I did 5 years probation at the time. And I ended up getting my kids back in 2007. At the same time I got my kids back from the state from my niece, their mother died at the same time, about a couple weeks later in that month. And, I stayed my ground. I stayed clean until 2018. I met another young lady in our church. I ended up marrying her. And I woke up one day and just realized this wasn't the woman I married. You know, she's stealing money out the cash register, having affairs behind my back with other people from other churches. She's the first lady of our church, but she walked out of our church and went to somebody else's church. And I found out I knew the person came by my house to fight me in my own yard about my own wife. It was just so, there was so much where I just I did my best to hold on to it, but it was just so many problems going on where I know I was wrong in a lot of ways, but putting me in prison right now ain't gonna help that. The only thing that we just make the problem more worse than what it is. I went to prison 2019 with a problem. And when I came out, I still had that same problem. I need some help. I don't want to live this way. I'm 97 years old, and I don't know how much more time I got left in this life, but I know I don't want to live it this way. Getting high and doing things to get money to get high with. I'm tired. Yeah, just throw myself to the mercy of the court just to give me some help.
Sir, it's not just this court, but many courts, since it looks like from the history I have since 1983, have tried to help you. And in fact, in 1985, there was even a prison escape. You have told me a very sad story. I believe that story. But at some point, you're not a kid anymore, you're a man, and you don't look to illegal drugs and alcohol to help you. And I understand that's how you were raised, but we do have this, 14-year gap where you were married, employed, crime-free, and learned your lesson, and then something bad happens and you went right back to drugs. And the problem, sir, is you didn't just go back to drugs. You didn't just harm yourself, you harmed others. Because when you give, share, or sell illegal drugs, you're addicting or killing other people. And you don't know how many people died at your hands, how many people you helped with their addiction, helped make it worse, or maybe somebody else start an addiction. It's all connected, sir.
Can I say something?
What?
This is the honest God truth. I've never been a drug dealer. I've been a drug user. I ain't never deal no drugs with nobody.
Well, sir, I have a history here. Did you ever share your drugs?
Yeah, we
Okay,
share.
that's called dealing.
We share.
Okay, no difference. No difference. I'm unclear what you think the difference is. When you share it, you can give it for free, you can get money for it, you could get some permission to sleep on someone's couch, whatever. You share it, you shared it, you dealt it. And now I have to deal you your just reward, which is prison. That was your agreement. That was not the initial agreement, but now I have one file turned into 4 files over the course of a couple of years. I am happy you finally want treatment, but you're gonna get it behind bars. So there's nothing I can do, it's your agreement. And sir, I asked about whether or not you broke the agreement because I think you ought to spend more time in prison, not less. And I'm very sorry for your health, but your drug addiction did not help your health. The only one that caused your demise was you. And this history is horrible. There's no real remorse for what you've done here. We have guns, we have property crimes, crimes against the Department of Corrections, against law enforcement, and a lot of drugs, sir. And there, in 2019, you were ordered to complete TRICAP and you absconded from treatment. So maybe at 67 years old, you want treatment now, but that's pending jail or prison, I should say. And you could have gone to treatment at any time on your own, but you didn't. So I hope this time you avail yourself of the treatment in prison. They've gotten a lot better, but I cannot have any sympathy for you at this point, especially since not only do we have delivery manufacturer, and we have heroin, cocaine, there's lots of things, alcohol that you've abused, but multiple counts of firearms. And we have people dying every single day, and firearms addiction, drugs, selling or sharing drugs, it all goes together. This has to stop now, sir. And if I didn't accept the agreement, I would delay matters more, so I'm going to accept the agreement. So therefore, sir, you are remanded to the Michigan Department of Corrections for 24 months to 360 months with credit for 248 days served. You'll pay a crime victims assessment in the amount of $130 and a state cost in the amount of $68. Those will not become due until 2 years after your release, sir. You can return pop-outs and get that paid off during that time. You also, once you are released, or maybe you'll do it before, you need to clean up these civil infractions because they can do a warrant and you can walk out of prison only to go back in because you haven't paid those, so figure it out. Maybe since you're arrested, they'll withdraw the money you owe, maybe they'll give you a time extension, but you need to deal with that, sir. You need to be accountable on all fronts. You need to be crime-free, drug-free, alcohol-free. and not turn to drugs when you have a problem. There's nothing in a divorce decree that gives you the ability to have get out of prison free card because you were so affected by the divorce. You somehow have permission to violate the law and use and sell drugs. So your excuses are simply excuses that fall very short, sir. I hope you use the tools you learned. I do have, and I looked at this treatment plan. It's an exceptional treatment plan. They did right by you. The only one not doing right by you is you. Avail yourself of treatment in prison. Follow a treatment plan. Ask for help. Stay clean and sober. I think I noted that you have a sister who might be like 97 years old. You got longevity in your family. You're lucky. You're blessed that way. So you're also, by using all these drugs, killing that gift that God gave your family. There were a lot of issues in your family, but you could have stepped outside the drugs at any of these times that you were before multiple judges on these 10 felonies, and there's much more because they were all plea deals. So my hands are tied. You will be provided mental health treatment and health treatment in regard to the multiple issues you have physically and also in terms of your addiction issues. You will attend AA, NA, or CA and any treatment programs they have. How do you support yourself, sir? SSI, SSD, work? What? All right, so you'll participate in any kind of trade school and any programming they have for finding you a home, halfway house, whatever they do in terms of the continuing treatment, as well as perhaps applying for SSI. Have you ever worked?
Yeah.
What kind of work do you do? Okay, so you have the ability to get a job, so you'll also be part of some kind of work seek program both on parole as well as while you're incarcerated. They have different kinds of programs where you can learn to do applications and do other things. So I don't know what prison you'll be at, but you will avail yourself of those things you need. So once you walk out of prison, you are no longer homeless or without employment, sir. If this keeps up, you will die in a jumpsuit in prison. Would you like to die a free man or an imprisoned one? Well, that's the right answer. Let's figure out how to get there. You know how to make good choices. You're certainly articulate. You have a 7th grade education, but you talk like you got a college degree. So you learned a few things along the way, but let's use them for good instead of evil. Drugs are evil, sir. They kill people every single day. Guns kill people every single day. Stay away from all of that. Choose the right side. And you know what it is. Obviously, you said you were a pastor.
Yeah.
So I don't know what you're going to say to God, but you certainly turned your back on him. He's still there. I understand he lives in jail and prison. People find him there all the time. Maybe you can do some good to your fellow inmates and your own rehabilitation, finding him in there and having a few heart-to-hearts. You have 42 days to appeal and to request appellate counsel. I just want to make it clear that he does get the credit for the 248. Anything else?
No, Your Honor, I've given to the court the NALI process for the other files that will be responsible.
And Your Honor, for the record, I am providing him a notice of right to appellate review.
Sir, do you acknowledge receiving your appellate rights, your 42 days to appeal to request appellate counsel? Do you acknowledge that?
Yeah.
All right, thank you. Court is signed and announced. If you wait a moment, counsel, make sure you get copies.
Thank you.
Thank you, that's all for the record.
Alrighty, friends. About ready to wrap it up here in about 15 or so minutes here on TCF Live on this fine Wednesday. But we got time for one or two more things. Let's go down to Louisiana and visit with our good friends at the Parole Board.
Okay, good morning.
Good morning.
Okay. Is this Gabriel Francis?
Yes, ma'am.
Okay. Gabriel Francis, you're here for a parole revocation. And my name is Carolyn Stapleton. And today is May the 20th, and I'm from headquarters and headquarters staff. Will you introduce yourself, please?
Shayla Thompson.
Okay. And Jasmine Thompson. Okay. And on the panel today is myself, Carolyn Stapleton, Pete Freeman, and Steve Prater. So I'm gonna ask you, do you have I want you to introduce yourself with your DOC number, please.
Gabriel Francis, 5040202.
Okay. Do you have a questionnaire?
Yes, ma'am. I believe so.
Yes, sir. According to how you answered the questionnaire, you're not considered eligible for appointed counsel. You're aware of that?
No, ma'am. I wasn't aware of that.
Okay. Did you want to retain or hire your own counsel?
I mean, at this point, I can't go for it.
Okay, that's understandable. Okay, well, thank you very much. Okay, so today the person that is going to be handling your case on the panel is Mr. Pete Freeman, and I'm going to hand the case over to him.
Okay, Mr. Francis, I'm going to read the conditions that is alleged you violated. You plead guilty or not guilty, and we'll discuss them as we go. Condition number 4, I will not engage in any criminal activity, nor will I associate with people who are known to be involved in criminal activity. I will avoid bars and casinos, and I will refrain from illegal use of drugs or alcohol. You're on 2/18/26. You tested positive for opiates, and you also admitted that you used marijuana on 3/3/26. How do you plead to those charges?
Not guilty.
Okay. And also on 2/18/26, you obstructed justice in that you would not give the probation officer your telephone. How do you plead to that charge?
Not guilty.
Okay, tell me about it. And please sit up straight. Don't sit like that.
No, I am sitting up straight. Like more?
Okay, no, that's good. You're good. All right. So tell me about the phone. I want to know about this phone. Why wouldn't you give him the phone?
Because when I got into the probation and parole office, he asked me to come to the back. I got to the back and he asked me about a piss test. Well, I wasn't able to piss, but I put like 2 drops of pee in the cup, and he said it was dirty for opiates. I didn't know what opiates is, and I told him no, like it was impossible. Maybe it wasn't enough pee. He then asked me, he said, well, let's go get a second look. So got back there to the office, and he placed cuffs on me, and then they started reading me my rights. Then I had the right to feel like this was all like a trick or some kind of setup. So then once they read me my rights, then he said, they asked me about my phone, to go through my phone. But to my understanding, you just read me my rights, which I have a right to remain silent. So I basically chose to remain silent and wouldn't allow them to do anything because I didn't know, I mean, what you charging me with. What am I, like, what criminal conduct did I engage in or anything for this basically to take place or for you to handle me like this?
Right. Okay, well, let me ask you this. I mean, did you sign a sex offender contract when you were placed on probation?
Yes, sir.
Okay, didn't it say that they have a right to look at all of your computers, telephones, any kind of stuff like that?
I didn't really remember that part of it. No.
You don't remember that you couldn't have any social media?
No, I don't have any social media.
Okay, and you know, while we're at it, tell me about these phone calls with your mother. I listened to them. Tell me what you was trying to accomplish there.
Me and my mom has the same basically account. Like she can look at my account because it's basically her account. I use a phone number from off of her account. We share the same accounts, right? So whenever he told me that it was a social media account, he said it was Facebook. Somebody told him I was on Facebook and I was sending threats. So when I got to the jail, I called her to make sure. I wanted her to see from her account. Like if she go and look up the information on her account, she would be able to see. Which when she went and seen, she didn't see no what he was saying, like no social media.
Right. It sounded like, I mean, I ain't gonna lie to you, I listened to both telephones. It didn't sound like that's what you was trying to do. It was trying to make sure you wasn't associated with any Facebook accounts, it sounded like, and you was trying to get your name off.
No, I told her to make sure I wasn't on there at all. Like make sure nothing was linking me to that. Because even though
Okay, all right, so you was trying to make sure that you wasn't linked to it.
yeah, because I heard what he said. So I just basically called her to make sure, like, look, take a look at this and go and see. Make sure I'm not linked to none of this.
Okay. All right, well, I'm gonna go on and read the other violations, and we're gonna hear from your probation officer, Miss Melissa Barris. So hold on, Miss Barris. I'm gonna get to you. Okay, so the other violations all deal pretty much with the same thing. I will truthfully and properly answer all questions directed to me by my parole officer. On 2/18/26, they wanted to inspect your phone. You failed to answer truthfully about your phone, stating you left it at work. It was determined it was in your car. And then once they got it, you didn't want to give them the code to get in. You saying that you didn't want to do it because they read you your rights and you wanted to remain solid. Is that correct?
Right. I was just being, and he knew that because I was being sarcastic. I already had been stated that I wasn't going to give him my phone. So it was basically a sarcastic statement, like just being like, I left it at work. I left it in the car. Like, because I already made it clear that I wouldn't give him my phone after you didn't read me my rights.
All right. And I agree to live, visit at my residence or place employed by the parole officer at any time. I also agree to searches of my person, property, residence, and/or vehicle when reasonable suspicion exists that I have been engaged in criminal conduct. You pleaded not guilty to that, and it was the same thing. You didn't want to let them inspect your phone. And then number 10, you owe $1,827 in fees. Have you ever paid anything on your fees?
No, sir.
Okay. Were you ever working while you out?
Yes, sir.
Okay. Why you didn't pay on the fees?
Because I was paying rent. I paid my rent. I paid to basically to live. I mean, and I was going to pay it. I mean, that month I got a call and I was going to pay it.
Okay. Well, let's hear from Miss Melissa Barris. Miss Barris, tell us your side of what's going on.
Well, Mr. Freeman, I'm actually the supervisor of his
Yes, ma'am.
officer, which is Officer Cato. And on that date, on February 18th of 2026, when he was brought to my office for me to do the electronic inspection of the phone, based on those complaints that Officer Cato received, he first acted like he did not have the phone. And then he also, I did give him his Miranda warning due to my training, because in the event that criminal activity was confirmed, I didn't want the evidence to be suppressed because I didn't know the nature of that evidence. And he refused to provide the passcode. He refused to allow me to do the electronic inspection. His sex offender contract was brought to the office along with his certificate and his file, and I showed that to him, and he still continued to not allow me to do the inspection of his phone.
Okay, thank you, ma'am. Okay, let's hear from his officer, Mr. Cato. Thank you for joining us today, Ms. Barris.
Good morning.
Good morning. Okay, tell us what went on with him and how he violated his probation.
Can, give me just 1 second. I'm gonna shut my office door if that's all right.
Sure. Yes, sir.
All right. So on the morning of February 18th of this year, I received a phone call from Joycey Carter, who advised me that she was at the courthouse filing for a petition for protective order against Gabriel Francis. She alleged that he had been sending messages to her and her husband via Facebook Messenger. And she then provided me with the petition for protective order. We looked up the name that she provided for his Facebook. Ms. Melissa and I looked at it on Ms. Melissa's work phone, and it did appear that it was his active Facebook account based on the pictures on the Facebook. So we called him in because we wanted to verify if he had social media active on his phone. We called him in that day. I did drug screen him. He was only able to provide a very minimal sample, it was probably about 2 or 3 drops. So not all of the lines even read, but he was positive for opiates. His claim on that day was that he had taken one of his own pain pills from an old prescription that would have no longer been valid. I asked him if he was able to provide that prescription to us. He said he was not, but he said it was his own prescription, just an old one. I did say we were going to get a second opinion. That was my way of bringing him back to the office. We had been instructed due to the instant offense that he was on for, that when we searched his phone, we were to have him secured in handcuffs, because he's currently on supervision for disarming an officer. We brought him back. Miss Melissa began to read him his rights after I put him in handcuffs, explained to him, you're not under arrest at this time, but we are detaining you. Miss Melissa's going to explain everything. She advised that we wanted to check his phone for any illegal activity. She began to read him his rights. He refused to provide his phone, said, I left it at the office. I left it back at work. He was working at a hotel. Said I left it in the room there. I explained to him, was like, well, you texted me when you first got here, so there's no way you left your phone there. He's like, well, I don't have it. I don't have it. Finally, another officer went outside, was able to obtain the phone from his sister, who was parked outside, but then he wouldn't give us the passcode. We explained that, well, if you refuse to do this, then we are still going to book you for parole violations. And he said, all right, let's go. Take me to jail. So at that point, we then, I served him that same week with a notice of preliminary hearing with those violations. We reached out to the Attorney General's office regarding the investigation for his phone, because we did confiscate his phone at that time. Since that time, I don't know if y'all have received it. We had another preliminary hearing on Friday for him because the Attorney General's office has issued arrest warrants for 4 counts of unlawful use of social media and 2 counts of failure to register as a sex offender.
So do you know what they found on? They did find he had an account then.
So that was through their searches of, because they ended up subpoenaing records from Meta for Facebook, Instagram, and Threads. So they were able to find it. They were never, I don't believe at this time, I don't know if they've actually gotten into his phone, but they have found the other information about him.
Yes, sir.
Yes.
Okay. Does any of my colleagues have a question for Ms. Barras or Mr. Cato?
I don't.
Okay. All right. I have no further questions for the offender. Do either of y'all have any questions?
I don't. Mr. Prater?
I have no questions. Thank you.
Ready to vote when the panel's ready.
Mr. Freeman, we're ready to vote. You would vote first.
Yes, ma'am. Okay, Mr. Gabriel, it's quite obvious. You wouldn't give him the phone and you signed the contract. So that's the end of that. I find you in violation of condition number 4, number 7, number 9, and number 13, and my vote is to revoke.
Mr. Prater?
Yes, sir. My vote is to revoke. Also, when you're on a sex offender contract, you're not supposed to be on your phone or social media, and to find out or not, you got to let us inspect it. And I think that you're very hard to supervise, very hard to deal with, got a horrible attitude, and in violation of the conditions mentioned by Mr. Freeman.
So you find that you revoking for the same conditions,
Yes, ma'am.
correct? Okay.
Correct.
And I concur with Mr. Freeman. I'll revoke you also for the conditions that he mentioned earlier. So today, sir, your parole has been revoked and the time is 9:13 at Lafayette Parish Correction Center.
So if you're shocked by that one, put a 1 in the chat. I'm not suspecting we'll see a lot of 1s. So our 3 hours are up, but I've managed to get a decent amount done while we've been streaming this morning. So we're going to go a bonus 30 minutes. I hope to get back to 4 hours soon, but I've just been so behind on work. But today we have a little extra time. Let's go. Oh, so many choices. Michigan. Back to Judge Simpson.
And good morning, Police Court, Your Honor, Attorney Damian Cass, P number 85852, appearing on behalf of the second case for Mr. Brian Blair. Mr. Blair, if you can hear, state your name for the record.
Byron Blair.
Thank you, sir.
Thank you. What are we doing?
Your Honor, after having a discussion with co-counsel on this and with brother counsel APA, we received the offer last night, and at this time, we are now willing to accept that current offer and would like to set a final settlement conference.
In both cases. Jury final settlement conference will be set June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Bond will continue. Everything's working.
Hold on, I got to report. Hold on. I have to be in person.
I'm sorry? Yes, those are in person.
What was the date?
June 5th for jury final settlement conference. June 8th for jury selection.
Okay.
In person. Thank you. Bond will continue.
Thank you, Your Honor.
Everything else.
Hugo Mack, who let us know he's running late. You do have your recall from Ms. Barnwell.
Are you ready, Ms. Barnwell? Yeah.
Everyone's more, I mean, hopefully it's show up on the Zoom, but.
Okay. I'll show you. So. You're ready to do it? Okay.
Yes, somebody's calling me right now.
Okay.
Sorry.
But somebody that's important for all of us, or are you just letting me know?
Hello.
No, I'm kidding. Go.
I'm just at it with. Can I just go?
Yes, go. No, somebody was calling me too, but I didn't tell him. I mean, I would have. Think it was a client? What's his name? Well, let's hope it is. So, and we're waiting on, I don't have a watch today. Out of here. And Mr. Mack was coming from downtown.
Yes, sir.
All right.
Something. Like,
The jail is up.
the jail is up here.
Are they ready? Are you? Mr. You need more?
I will make do with what I have. I don't want to.
No, I mean, well, I want to make sure that you have what you need, but why don't I do this? Let Ms. Barnwell know I'll come back out. We'll call her case. I've got to wait on Mr. Mack. That'll end that block. We can get set up for the next block, see where Mr. Cook is. Go on, quarter stand in recess. And Ross.
Alrighty, I guess we're not getting much out of him at the moment then, but let's go back down to the board. They have a new contestant.
All right. My name is Carolyn Stapleton. I'm the chairman today on your panel. And you're at Bossier Parish Medium Security Facility. Anyone in the room that would needs to introduce themselves?
Deputy Danford here at the Bossier Medium. And
Jason. I'm sorry, I can't hear y'all. Can y'all get closer to the speaker, please?
Deputy Danford here for the Bossier Medium.
And Jason Johnson with the Steve Hall program.
All right, Jason Johnson. Okay. Thank you. Okay. So the time is now 9:27, and it's May 20th. And I'm going to get you, Mr. Carter. Well, let me tell you, the panelists today, myself, Carolyn Stapleton, Pete Freeman, and Steve Prater is on the panel today. And the date is May 20th. Mr. Carter, will you please introduce yourself with your name and your DOC number for the record?
Cortland Carter. My DOC number is 541073.
Okay, thank you, sir. Okay. At this time, your case has been assigned to me, so I'm going to read out the rule violation. At your revocation hearing on 12/4/2025, in lieu of revocation, the board ordered you to complete the long-term DOC substance abuse program. You failed to satisfactorily complete the program due to rule violation number 7A, disrespect, and rule violation 5B, aggravated disobedience. How do you plead for this, sir?
Guilty, ma'am.
Guilty? Okay. All right, well, let's just go over to Mr. Johnson, who is from the program, and see what he has to say also, because you did come today. I'd like to recognize you. Mr. Johnson, you have anything you'd like to say?
No, ma'am, I really don't have anything to add. Thank you.
Okay. I'm sorry, I forgot to ask you. Did you get a questionnaire, sir? Do you remember a questionnaire? We can put it up on the screen. Yes, sir. Mr. Carter.
No, ma'am.
Okay, do you recognize that?
No, ma'am. That says no, ma'am.
Wait, hang on 1 minute. We're going to get it.
Is there a chance we can turn the volume up there, or he can sit very, very close? Something with Bossier?
Yes, so we can barely, it is true. It's very difficult to hear you.
Okay.
Can you speak up a little more, Mr. Carter?
Yes, ma'am. It's still.
Okay, that's a little bit better. When you raised your head up, I could hear you a little bit better.
Okay, yes, ma'am. What about now?
Yeah, I can hear you. How about Mr. Prater, Mr. Freeman? Can you hear him?
I can hear him, but I'm still pretty sorry. It could be turned up louder. Something wrong with the volume there, because we couldn't even hear the deputies.
No, we couldn't. Okay, do you recognize that questionnaire, Mr. Carter?
Yes, ma'am.
Okay, based upon that questionnaire, you are not eligible for appointed counsel. Okay? All right, thank you. All right, and you pled guilty to the rule violations that I just read, correct? Okay. Mr. Freeman or Mr. Prater, do you have anything to say?
Ready to vote.
Ready to vote.
Okay, Mr. Carter, based upon the fact that you pled guilty to the rule violations, today you're, which was violation number 7 and violation number 5, your parole has been revoked. And, that concludes our,
Ms. Stapleton,
yes, what?
we just said we were ready to vote. We hadn't voted.
Oh, I'm sorry, I did that again. Okay, Mr. Freeman and Mr. Brady, I just passed y'all up, I'm sorry. Mr. Freeman,
Okay.
what is your vote?
Okay, my vote is to revoke. He admitted violation condition number 7.
And Mr. Prater?
I concur, revoke, admitted to violation condition number 7.
Okay, all right, so based upon, your plea of guilty to violation number 7, the board members, including myself, have revoked you, violation number 7.
You've been so bad, Mr. Defendant, sir, that I don't even need to call on my fellow board members. I know exactly how they're going to vote. We're just going to go ahead and revoke you. Oh, wait. Maybe we should get votes. All right. Let's head back up to Michigan Judge McNally.
B 24B147075B 24B147048C 24B147075A 24B147048A. Okay. Go ahead, your appearance.
Yeah, thank you, Attorney. Good morning, Attorney Thomas Courts, P77177. Here on behalf of the defendant, sir, please state your name directly.
I can't hear a word you just said. He's got 24 cases. These are 24 cases, right? He just didn't show up? Is that what happened?
I believe so.
This is actually an October 23 case. You live in Brownstown?
Yes, sir.
Why didn't you show up on these cases? Did I arraign him?
You did, sir.
Did I set up cash bond?
I believe you did. He wasn't in custody, I believe, at first.
Okay. Where does he work?
No, Judge, I've just asked that. He doesn't, and I would ask if the court would consider declaring him dead just so I could try to get him some experts through the county.
Well, you're a retained lawyer, though.
Judge, unfortunately, he hasn't been able to finish paying my retainer, but I plan on seeing
I don't think I can do that. Not if you're retained. I don't think I can do that.
Fair enough.
I mean, I could be wrong if you want to cite something to me. I don't know what kind of expert you want, but what is this, alcohol?
It is, yeah, but my understanding, Judge, is that there's drugs involved and the alcohol limit didn't go past the. So it's become a little more generalized.
So what are we doing today? Adjourning this?
Yes, Judge, unfortunately, the government hasn't been able to use the video yet, and I need to. You might be able to effectively.
Call in the prosecutor, will you, John? Did I tell you to go over and get printed? Did you?
I was printed when I was in custody here.
You got to keep your voice up for me.
I was printed when I was in custody here the day of court.
Heather, this record was run on May the 12th. Would you double check and see if he's, I got all kinds of files here.
Yes, I'll run a new record right now, Judge.
Your name?
Caitlin Foley Carter, Boston Township.
Mr. Courts is asking about a video. Is the video still in existence?
It is, Your Honor. I'm just waiting for the police department to make the necessary redactions, and I'll get that right over to him.
guess we're having a hard time getting police reports from Brownstown.
That's what I heard. I always schedule police reports on the plea when I do the file, so you should have them.
I thought so. I thought so. When's my next Brownstown date, Heather?
The next one is June 17th.
All right, we're gonna have to set a trial date too on this. So I'll set this for a pretrial on June the 17th at 8:30 in the morning. And then I'm gonna set a jury trial. We're gonna have to pick a Friday, I think, in July or what have you.
Okay, let's take a look. Well, you are off July 10th. Let's go. And then the first Friday is a holiday. So July 17th would be the first Friday.
Is that good with everybody?
I got it.
Judge, if at all possible, the 24th would be more ideal.
Is that good with you? All right. So we're gonna have July the 24th at 8:30. Final pretrial, that's the jury trial date, final pretrial, June 17th at 8:30. Any and all motions to be filed by June 3rd and heard on June 17th. Okay,
Judge, I did get the new record back. It is showing that he was fingerprinted on the
Thank you.
charge for October 6th.
thank you. So that's what we'll do. I'm only writing on one of these, Heather, if you can just note that if you would. Okay.
Okay.
So you're all set. You can go down the hall, get your notice. Bond is continued. Anything else, counsel?
Nothing.
Anything else? What's it? Police reports. I had 3 sentencings out of Brownstown and I didn't police report on any of them.
If that ever happens again, Your Honor, I can run for you.
Yeah, I know you would. I get it. All right, thanks a lot. Thank you both. Have a good day. Kayla Nicole Zarnick, 265-415-211. Your name?
Bernard?
You're gonna set a formal hearing on this?
Yeah, I can pay everyone.
Well, that isn't the issue, ma'am. You shouldn't be setting a formal hearing on an expired plate on the basis that you can't pay it now. If you're responsible of it, I can give you time to pay.
Okay. The officer told me when he gave me the ticket, if I got it within 10 days, it would get waived. And then I found out that wasn't an option here, so that's why I just.
Did you get your plate renewed?
Yes.
I mean, I can set a formal hearing if you want, but that's,
Too much.
no, if you want to do it's pretty basic. Either you were or you weren't. This isn't a criminal charge. And I'm just telling you how long was it expired?
A couple months.
I mean, if your basis for setting a formal hearing is because you can't pay it today, I can give you time. If you want a formal hearing, I'll give you a formal hearing. It's an expired plate. It's pretty cut and dry. But I'll be glad to do that for you if that's what you want. I don't want to talk you out of doing something you want to do.
I will more time, that's fine.
I'm sorry?
I can just take more time, that's fine. Instead of the hearing,
So you want to plead responsible?
sure.
I don't want to talk you into it. If you want a formal hearing, I'll give you a formal hearing.
It's okay.
Okay, to the charge expired plate, you plead responsible or not responsible?
Thoughtful.
And you have your registration with you now?
Yes.
This citation was issued on April 12th. When did you go and get it?
April 22nd,
And when had it expired?
December.
All right, that's quite a ways. Look, I'll make it $100 for you. And tell me when you can pay this. I'll be happy to give you time to pay.
Next week,
I can give you more than that.
3 weeks.
Okay, I'll be glad to give you until, how about June the 5th? Is that good? If you need more time, you call the court or come in here on or before that due date. I'll be happy to give you an extension, okay? All right, best of luck to you. Thank you. Michael Carter Burke here.
He's in custody. Let me get him out of the breakout room.
Who's his lawyer? Does he have one?
Miss Patillo. And we do have another in custody out here that Mr. Carmen has. That is Mr. Edmonds.
Michael Carter Burke. I have 24I702893. And I have 26I415304. Just wait 1 second, Mr. Burke. Your lawyer's on her way in. Good morning, Ms. Patillo.
Did you call me?
I did, Mr. Burke. Your appearance?
Yeah, I'm at TOP 82378 on behalf of Mr. Burke.
Mr. Burke, your name?
Michael Carter Burke.
So let's take the flee and elude. He pled to attempt unlawful use, which is a 1 year. And I just simply fined him and ordered him to serve some jail time, and he has to serve 275 more days. If fines and costs are not paid is what I ordered, and he's in custody. He didn't show up for his show cause for failure to pay back on March the 4th. Ultimately, a bench warrant was issued and was brought in on May 1. I gave him a $6,000 10% bond on that case, and then on May the 6th, I reduced it to 6,000 PR. The same thing on the other case. He pled guilty to possession of drug paraphernalia on May the 6th. So I did not order a pre-sentence report or a screening. Anything, I mean, is he going to plead guilty to the failure to pay, or does he wish to have a hearing?
He doesn't wish to have a hearing, Your Honor. He can pay if he's released, does have this trust fund, he just has to go with his sister to get the money. And he indicated that his sister has put some money into his bank account, but he just has to get out to get to it to pay.
So is he going to plead guilty?
Yeah.
If you plead guilty here, sir, you could get 275 days to the failure to pay. Do you understand that?
Yes, I do.
You have the right to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in your own witnesses. You have the right to testify or remain silent. They have to prove by a preponderance of the evidence that you're guilty in order for you to be convicted of failure to pay. Do you understand that?
Yes, I do, Your Honor.
To the charge that you failed to pay $785, how do you plead?
I plead guilty.
Did you fail to pay?
I failed to pay.
And I ordered you to pay 50 per week beginning November 7th of 25, right?
I didn't know about that, but I'll definitely start doing that, or I can pay when I get to see how much money my sister put in the account.
Slow down.
I'm sorry.
I gave you time to pay when I sentenced you back on August the 12th, right, of 25?
I think you told me to come show up, and then you made an agreement. I didn't show up for the agreement when you made the agreement for me. I didn't know what it was, but you told me to pay
Right now, my sister puts the money in my account, so I can either start doing.
Sir,
Yes,
just answer my question. I ordered you to pay $725 when I.
yes, you did.
And I gave you time to pay and you didn't pay, correct?
Correct.
Anybody forced you to plead guilty?
No, sir.
He's got a dilemma here, you know that? Accept your guilty plea to that charge. And I've also got a possession of drug paraphernalia I'm going to sentence you on. He lives on Grays Drive. He doesn't show up. He didn't do anything. Now he wants me to take him at his word. Why can't he call his sister and have his sister bring the money here? I don't think I'm going to do this. He's going to be sitting.
She lives in Minnesota. I'm sorry.
You can access the money that you have. You want me to treat you like a baby?
Well, no. I have to go to probate court to get my stocks. I have to sell them, and I haven't been able to sell them yet. It's been a little bit of a process.
Well, you know what? That's your problem.
Okay, I understand.
I told you to come and talk to me if you couldn't pay your fines and costs. You didn't pay. You didn't come and talk to me. And then since then, you've gone out and committed another crime. I don't know what to do. I'm serious. I'm not going to release him on the off or if come that he's going to go out and get the money. It doesn't sound like he has real access. I don't care if he's a trust fund baby or not. If he was a trust fund baby back, or is now, he was back in August of last year. Did something happen? Did you just become this trust fund guy since August of 25?
I've just been waiting to sell the stock, and I just have never got around to it. I've been living. I just I gotta go. I just gotta sell the stock, and I was gonna get an attorney and to handle stuff. I didn't do it.
He's in the jail, so.
Well, you got a big problem.
I don't know what his housing situation was. For the first case, he does have a place to live. He's living in his mother's.
Who am I hearing? Heather?
I'm not sure, Judge. That may be the background from the jail. Everybody else is muted.
Okay, go ahead.
So he does have housing. He lives in his mother's old condo with his aunt. He does help his aunt out. She's 80 years old. She can't walk the best. For large amounts of money, he does have to go through probate court. But again, he indicated that his sister has put some money into his name. He thinks he's under the impression that she put about $1,000, which would cover the vote.
Well, then I don't know what to tell him. It's his issue. It's his problem. I don't know what to tell you. Did you make any calls and try to figure out a way to resolve this?
My aunt, someone took her phone, and I've been trying to write her mail. I've wrote her about 5 letters. I've been trying to call my sister, and last time I talked to her was when I was at the Groesdale police station. She said she was going to put the money in the account, so it could be on my ATM card right now. I just haven't got access to it. I was waiting to see what happened here. I'm pretty sure that she put the money in the account.
Why didn't you?
I've got my ATM card here at the jail. That's the only way I can check it if I went to the ATM. Other than that, I really have no other. I've got no other family member other than my sister and aunt.
They don't know what to do with that.
I mean, she's been helping pay all the bills. I'm pretty sure she put the money in there. She's been paying all my phone bills and out of the trust, and she's been paying the taxes.
Figure out a way to get access to a phone to call her and find out.
I've been calling her and she hasn't picked up. I keep trying to call her and I haven't ever picked up. I've tried her twice a day.
Yes, even if he was released this Wednesday, if court allows that, order him to pay upon release.
I mean, can I check the ATM here and try to pay it from here? I mean, I'm pretty sure the money should be there.
I don't think they're gonna let him out to check. Because the ATM is on.
They said I could pay the bail, but I wasn't sure what to do. So I just sat here but I think there's money in the account, in the ATM. If I can pull it out of here, I can pay I can try to see if the money's there.
You don't have bond in this case. I gave you a personal bond on May the 6th. What else is he being held on? Heather, did we not change the bond on May the 6th from PR, from 6,000 10% to a PR bond?
Oh, I didn't know that.
Was there?
Yes, we did, Judge.
No.
So they kept hold me. They never.
Hold on. Just let
Yes, sir.
me talk to somebody for a second. Did we submit new paperwork on the 6th?
We should, yes, we should have. We sent paperwork over.
Does he have any other holds that you know of?
Not that I know of, I think it was in your house. I might go ahead and
Heather, I don't see where we sent in another minimus.
Looks like I printed one.
Did you have somebody for Judge Hess?
304.
Does he have any other cases going on in this building?
Not that I can see. Let me pull up his name again on another screen here.
On the Wayne County Sheriff's side.
No.
It just has these.
Yeah, another camera, if you want to put those down there. Oh,
$300 bond and it's $6,000.
Those were personal.
Don't have it marked as personal, but it's in here.
I set 6,000 10% on May 1. May 6th, I reduced it to 6,000 PR. All right.
The court may want to put it over, and then if the bailiffs are gonna allow him to check the ATM, then that way he would be able to tell the court the money is on.
Who's Diana Burke again?
My mom that passed away in December. She passed away almost 2 years ago, December 2nd. And
you took her vehicle. This was
I
her
borrowed it,
vehicle.
and someone stole it from me in Detroit, and Detroit never made a police report about it. There's even precedent. I brought her car back a bunch. The Grovefield police even pulled me over and took the license plate off. I always borrowed her car and brought it back. Someone took it from me, and they gave me unlawful driving away. I wasn't going to risk my inheritance over a car. I'm 50, almost 51. I've never had a history of stealing anything, and this comes out of nowhere. I've never been a thief in my life, and I've never been a violent person.
All right, I'm sorry. Give me 1 second. You already served 90 days plus this since May 1. You've been in custody since May 1, is that right?
Yes, sir. I was before May when I was in Grovefield for 2 days also.
All right. I initially gave you 90 days.
Yes, I served those last year or this year in the fall and some of the summer.
Well, that's enough. Here's what I'll do. Heather, let's make sure we went over the paperwork on the,
Okay,
on this case, we're gonna, you're to pay $785. I'm talking about on the attempt to, unlawful use. You're to pay $785 or serve 112 days, credit $112, credit 112 days. So you don't have to pay that anymore. I'm releasing you. Then on the drug paraphernalia, serve 21 days, jail, credit 21. We're gonna release you. I hope you get your life in order, sir. I really do. Good luck to you.
Thank you. I'm gonna get my life in order, sir. Thank you very much.
You're welcome.
Thank you, Judge.
You have Dino?
All right, friends, that will do it for today. Thanks for hanging out with me for an extra half hour. Be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, half an hour earlier if you're a channel member. Tomorrow will be a Super Thursday since we're not doing Super Friday this week because of the holiday, so do join us then. Go have yourselves a great day. Look forward to seeing you all tomorrow. Take care. God bless.